Good morning.
Good morning.
Good morning.
All right, good to see everyone and hope all is well. And we will begin with case number 1, 23-2397 and 23-2398, Carl Culp versus Steve Reed. Good morning, Ms.
Good morning.
Cerise. Good morning. Be sure and watch the clock, all right?
Okay, I will. Good morning, everyone.
And that's a message for everyone, please, in the courtroom. Thank you.
Good morning, everyone. May it please the court, I'm Jeanette Cerisi, and I'm here representing Carl and Roberta Culp. Carl is a person who is a double paraplegic amputee suffering from obesity, depression, and PTSD. Carl believes the ADA applies to him, and Carl believes the ADA applies to the 2018 encounter he had with the police. Carl is appealing the trial court's order granting defendant's summary judgment on his ADA claim. To that extent, it's important to note that the defendants in their opening summary judgment briefs did not argue that the ADA does not apply to police encounters, did not argue that vicarious liability is not a way to assess fault under the ADA, and did not address plaintiff's claims that the entities themselves discriminated against Carl.
Ms. Cerisi, forgive me, but with respect to the ADA and the Rehabilitation Act claims, you assert that the wrongful arrest theory does not apply here. And you have relied only on the accommodations theory. Was any accommodation requested relating to his ability to exit the vehicle? And why would the officers think any was needed, given their observation that he was able to stand up from a sitting position in the wheelchair, place the wheelchair in the trunk, walk to the vehicle door, and sit without any help?
Well, so, Your Honor, this is a summary judgment standard, and so our facts are the facts that rule the day. And Carl's testimony is that he is a nearly 300-pound man that slowly got up out of his wheelchair, teetered alongside of his car, and barely made it to his seat before the officers put his hands on him. And that it is exceedingly difficult for him to get out of his wheelchair. As far as a request for accommodation, there's cases where it's said that if the accommodation is obviously needed, that there should be an accommodation made. But we did make one request when he was on the ground, or what I would construe as a request is when he said, "My legs aren't supposed to be getting wet."
So the request there was to put the prosthetic devices in the car or in the trunk or something?
Well, anything. Put some tarps over him, help him in the building, do anything, any reasonable accommodation to get his legs out of the rain and water. And I know
one point that Judge Lee observed is that unfortunately it was pouring rain that day, right? So they through no fault, of course, of his own, the legs, they were already wet.
Taking a short transition to his car, to get in his car, is far different than being left in the pooling water on the ground for 20 minutes.
What is your evidence that the actions of the police were related to his Mr. Culp's a disability. The only connection that I noted was the statement by the officer for him to comply and that they did not want to beat a handicapped man. And what that does is, I would think, at best, establish their awareness of his disability. But that was not at issue because it is undisputed that they saw him when he was in a wheelchair near his car. And as I noted a few minutes ago, saw him put on his prosthetic legs, stand, place his wheelchair in the trunk, walk around the car to the door, and ignoring their request to stop and talk, enter the car. So, in other words, what we have is officers who are aware of his disability, but were also aware that he was capable of walking, lifting, sitting. And, when he refused the officer's commands to cooperate, Carl's wife asked him why he did not get out of the car. So that must have made it clear that to the officers that he was capable of doing so, and that the obstacle was not any physical limitation of his disability.
Well, the thing about this is Carl's wife also testified or put in her affidavit that she knows that it's exceedingly difficult for him to get out of the car. And perhaps the reason she asked him, why don't you get out of the car, was simply because she was scared. These are issues for the jury to look at and weigh against each other. These are competing facts that we have on this record, and on summary judgment, our facts are to get credited here. The direct animus here is, from our side of the story, he was not even yet refusing commands. All that had been said is, may we speak to you? He said, no, thank you. That's not a command. Any citizen free on the street is allowed to say, no, thank you, to a police officer's request to speak to him. He gets one leg in the car and he's got hands on him, as our facts, and they say, we don't want to beat the A of a handicapped man, at least twice. And so then they directly do such. If that's not a sign of intentional discrimination under the ADA and taking one's distinguishing character into account and then proceeding to beat, tase, pepper spray, hammer fist, I don't know what is.
I'm a little confused here, counsel. As I understand it, there's no claim for wrongful arrest, correct? And the jury rejected any claim for use of excessive force?
Yes.
So, what is this a property damage claim? About water damage to his prosthetic legs? Or what are we talking about with damages here?
This is pain and suffering. They twisted his arm. He's been hammer fisted.
So wait a second though. What happened to what consequences are there from the excessive force verdict?
There are no consequences from the excessive force verdict, but this is a wholly separate claim. This stands different than the constitutional claim.
So the theory is that what the police officers did would have been perfectly permissible if he were not disabled. Is that right?
No. So excessive force stands in a different realm, in the constitutional realm, and that the jury found they didn't commit excessive force. In the ADA, force by discrimination need not be excessive to meet or break the standard of the ADA violation or make an ADA violation.
Can you point us to cases that have found that police officers complied with the Constitution in an arrest but violated the ADA? Your briefs talk a good deal about, in essence, inviting us to weigh in on this larger abstract question about how the ADA applies to arrests. I guess the Fifth Circuit has said it does not, and other circuits have indicated it may, but as far as I can tell, have not actually found an officer violated the ADA.
Well, in Sheehan, they leave the door open.
I understand the door is open, but
Yeah.
I'm looking for guidance as to what a case would look like in which an officer complied with the Constitution, but was found to have violated the ADA in treatment of somebody with disabilities in an arrest.
I don't think I've found such a case, but I really think that the constitutional analysis shouldn't get intertwined with the express statutory dictates of the ADA.
Well,
If-
how express are they is one of the questions,
Oh.
but that's, go ahead.
Could I pause you on that point? So you know, of course, that in Kane, we assumed
Yes.
that the ADA Title II for shorthand applies to police encounters, and we further assume that there's vicarious liability. If you set aside the assumption, I think it's settled in our case law, right or wrong, our cases say that there's no individual liability under Title II. So can you walk me through the statutory argument?
The vicarious liability
Right.
argument?
So why under the language of 12132 Title II, why is there vicarious liability?
Okay, so
How do you get there?
I don't think Gebser foreclosed vicarious liability. I'd like to start with the fact that Title II points back to the Rehab Act, which points back to the Title VI remedies. When Gebser was decided, they were deciding Title VI and Title IX. Title VI and Title IX are wholly modeled after each other. Title II is not modeled after Title VI or Title IX. It's not cut from the same
It's not
cloth.
spending clause litigation either, or legislation either. So just in the interest of time though, set that aside.
Sure.
How do you get there statutorily?
For
And vicarious liability imposed here upon either the Allen County Sheriff in his official capacity or the chief of the Fort Wayne Police Department.
Well, I don't think it's been foreclosed because it's not a remedy, right, or procedure, and that's the only thing that we are looking to is a remedy, right, or a procedure. And then also that the plain language of the statute talks about it being an instrumentality.
So
Okay.
I don't, for my part, the starting point has got to be what is the language of the statute, and if you had I'm gonna by analogy draw upon Monell. If you had a Monell-like set of facts that the police department had a policy, there was a pattern in practice, there was inadequate training, I think you could get there under the language of 12132, but that's not the way the case is presented. The case is presented in terms of two Fort Wayne police officers who you want to impute their actions to their employer and hold the employer liable. Okay, my question is, how do you get there legally when you don't have a Monell-like evidentiary showing?
Okay, well, first let me say that two of the officers that were there, under their facts, one was a corporal of training, and we don't think that you have to go all the way to the very top of the chain. One was a corporal in training, Corporal Lawhorn, and another was a sergeant, Sergeant Griffin. So they could arguably be...
The two officers that were involved in the encounter, though, were Miss Woods and Mr. Shoeline.
Correct, but the officers that showed up during the legs not getting wet scene. We're higher level officers. But as far as your statutory question, I look at 12-131, and it talks about other instrumentality of the state. Public entity means other instrumentality. And we did cite case law for you that other instrumentality can mean agent. These officers are simply agents of the state, officials. Under section 12131, instrumentality. May I reserve the rest of my time? Or would you like further questions?
Why don't you reserve, and thank you.
Okay, thank you.
Okay.
Good morning. May it
Good
please-
morning, Ms. Pure.
Good morning. I represent the city defendants and the county defendants on this appeal.
Even though I said good morning, you might want to state your name.
Oh, I'm sorry, Carolyn Trier.
Thank you.
Sorry about that. So with respect to the claims under the ADA and the Rehabilitation Act, I cited a case from the Seventh Circuit Court of Appeals, King versus Hendricks County Commissioner. And in that case, the Seventh Circuit assumed without deciding that the ADA and the Rehabilitation Act applied to the officer's interactions with the plaintiff in that case. And that case is pretty much on point with our case. In that case, the plaintiff suffered from paranoid schizophrenia, and on November 29th, 2016, 2 reserve deputies went to the King's home to perform a welfare check after the plaintiff had called 911 requesting help. Mr. King walked outside of his house towards the reserve deputies and pulled out a 10-inch knife from his shorts pocket. The deputies yelled at him to stop and drop the knife. He disregarded their commands, kept moving forward, and he was shot and killed when he was approximately 8 feet from the officers. The Seventh Circuit, like Judge Lee in our case, granted summary judgment on the ADA claims and the Rehabilitation Act claims, and stated that the record before us does not indicate that Hayes was deliberately indifferent to Bradley's disability, and stated that there was no evidence that but for the alleged discrimination on the basis of his disability, Bradley would still be alive. And we have that same case here. There's been no evidence presented by the plaintiffs that but for the alleged discrimination on the basis of Carl Culp's disability, that Officer Shulian and Officer Woods would not have used the force that they did. There's no evidence in this case that the officers were deliberately indifferent to Mr. Culp's disability. When you look at Mr. Culp's deposition testimony, they're claiming that this is a failure to accommodate his disability. When you look at his deposition testimony, there's not even any type of request to accommodate his disability. And in fact, it just shows his continued resistance and refusal to follow the officer's commands.
What if this did not occur? But what if the Culps had brought a case stating that the officers should have been aware of his mental state? Where would we be then, do you think?
Well, the call was for a suicide threat, and they were taking him in for a mental health check. And by statute, by the Indiana statute, it's the same as an arrest. They can use the same force under Indiana law to arrest him. And so there were exigent circumstances in this case where he was not compliant. His wife could have driven off. He could have had a box cutter or weapons in the car. So really, it's not even relevant in this case that he was they couldn't have treated him any differently. They had to get him out of the car.
Ms. Trier, can I pause you? Can you Judge Rovner, I think, in my view, that's a really important question she's asked. And can you step back from the fact pattern for a second?
Yes.
Okay. And it's very easy in a context like this to talk about Mr. Culp being arrested. Mr. Culp was never arrested, right? This is not a crime situation at all. It's a mental health intervention situation that the police were called upon. As a legal matter, when we're thinking about the application of the ADA to police encounters, what I'm hearing in Judge Rovner's question is, does that context matter? Because there's no probable cause to believe that Mr. Culp committed X or Y crime.
Okay, I understand your question.
And that the reason I'm asking that question is, in our panel opinion in Kane versus Hendricks County, the court identifies, mental health intervention as possibly being a different context
Yes.
than a response to a call that somebody has committed a violent crime, for example.
Yes. Well, they knew that Mr. Culp was suicidal. It was called in from his psychiatrist's office that he was suicidal, so they were well aware of that. They tried to talk to him. They asked him to come back inside the medical building so that they could talk to him.
Right, so now what you're doing is you're shifting to the facts and the evidence. My question is, as a pure legal matter, does forget the facts and evidence for okay. If we have to answer the question that we haven't answered so far, would you tell us that the context, a mental health intervention, is legally relevant or legally irrelevant?
Well, I think it's always going to be relevant
How?
in that how they deal with a suspect or a person that is having a situation that has some type of mental health issue
Okay,
going
now
on.
translate that legally. So if you had to write an opinion saying that the ADA applies to police encounters, I know that's not the outcome you're at, okay, how would you articulate its legal relevance, mental health vis-a-vis arrest, law enforcement?
Well, I believe it's one factor that the police have to consider. I mean, it's hard for me not to go back to the facts because it is a factor. It's one factor to consider, but they also have to consider whether the person is a threat to himself, a threat to another person. I mean, officers are trained that suicidal people can be the most dangerous people because they'll take other people out with them. So they have to, that's one factor to consider in the analysis. But they still have to they have to help that person, not harm himself. They have to watch out for their own safety. So it's one factor to consider in the legal analysis.
Now, we didn't discuss this with, excuse me, this Cerisi, but do you want to discuss the cross appeal or not?
Yes, I do. Would you like for me to do that now or at the end?
Whatever suits you.
Okay. I think I would like to discuss Mr. Culp's deposition testimony because it's highly relevant to the issue of whether there was any request for accommodation or if the officers even knew he needed an accommodation. As stated earlier, the officers saw Mr. Culp stand up out of his wheelchair, put on his prosthetic legs, stand up out of his wheelchair, put the wheelchair in the back of the car, walk along the passenger side and get into his car. So the officers had no idea whatsoever that he would not be able to stand up out of his car, and he never articulated that to the officers. In addition, with respect to the prosthetic legs getting wet, Mr. Culp himself had already been out in the rain with his prosthetic legs before the officers even made contact with him. He took him out of his trunk and put him on in the rain. So to argue that the officers failed to accommodate that, his prosthetic legs had already gotten wet because of Mr. Culp's actions.
Of course, there's a difference at being out of the rain. I mean, in the rain and, on the ground in puddles for 20 minutes, is there not?
Well, I think the officers did what was reasonable and what they could in order to keep this person from harming himself. And the fact that it was storming that day, I mean, there's not a lot that they could do about it. And it happened outside. They did want Mr. Culp to come back inside the building, and he refused to come back in. So, but Mr. Culp testified in his depositions that the officers wanted him to come back in the building. He admitted that. He testified that the officers wanted him to get out of his vehicle. He admitted that he refused to comply with the officers' request. He stated to the officers that he would like to see them try to remove him from the vehicle. He admitted that he removed his glasses and placed them on the passenger side of the dashboard. He admitted grabbing the steering wheel and was using his head against the B-pillar and his arm wrapped around the B-pillar on the outside of the car, and he was holding on. He admitted that he specifically braced himself in the car and hung onto the steering wheel so the officers could not remove him. He admitted that he refused to get out of the vehicle. He admitted that if the officers told him he did not exit the vehicle, he would be tased. He admitted that the officers attempted to remove his left hand from the steering wheel. He admitted that he still grasped the steering wheel. Mrs. Culp testified that she heard the officer say to Carl Culp, "We want to talk to you." Mrs. Culp heard Mr. Culp say to the officers, "No, thank you." Mrs. Culp heard the officers keep saying, "We want you to get out of the vehicle. Get out of the vehicle. We want to talk to you." Mrs. Culp testified her husband wouldn't get out of the vehicle, and she even said, "Why don't you get out of the vehicle?" When you look at his admissions and his deposition testimony, he's not a man who's asking for accommodations from these officers. So even if the ADA and the Rehabilitation Act applied, there's no violations. There's no deliberate indifference to his needs. There's no failure to accommodate his request.
Ms. Trier, could I ask you about a different kind of factual context? I've seen a number of cases where somebody who suffers from diabetes winds up, for example, behind the wheel of a car and is in insulin shock. They may behave in ways that make it appear similar to if they were intoxicated. And that can lead to some very tough, sometimes violent encounters with police officers. Do you have any thoughts about how the ADA and or Fourth Amendment apply in that kind of a situation where the officer may or may not know about the reason for the behavior?
Right. Well, as you know, under the Fourth Amendment, when you look at the totality of the circumstances, it's from the perspective of what the police officer sees and knows, and not what he finds out after the incident. And, you know, they did know he was suicidal, which means he was a danger to himself and others, and he could have been a danger to his wife. So I understand, you know, I've read the cases where, you know, somebody's having a diabetic insulin reaction and an officer might interpret that they are intoxicated. But I think that's just one factor that the officers look at, and you have to base it on what they knew at the time. What these officers knew was that Mr. Culp was suicidal, and the call had been from his psychiatrist's office, not just a family member.
To go back to a question that Judge Scudder was asking you a few minutes ago, I guess you were saying the officers here had legal authority that's in essence equivalent to arrest power,
Yes.
right? And the resistance here seems to have shifted things very, very quickly into the equivalent of a resistant arrest. Is that right?
That's correct.
Okay. Do you have any doubt that if officers violate the ADA or Rehab Act, their department would be the entity that would have to answer in damages if there are awardable damages?
Well, I cited that case where the chief of police or the sheriff would have to have knowledge that it was taking place.
Why isn't it just straight respondeat superior, the way it is with an employment case?
When would it be?
Why is it not?
Why is it not?
Yeah.
Well, I think it's more. It should be more looked at the way a Monell claim is looked at. where
And
there's-
why is that? Because there is no possibility of individual liability under these statutes, correct?
That's correct.
So that means as long as the senior officials are not aware, there's no accountability if lower level officers violate the law. Is that right?
That would be my position, that would be what I would argue.
And
because it's-
based on what in the statute?
Oh, well, I would base it, the analysis should look more like a Monell claim.
I know that's your
Yeah.
conclusion. How do you get there from the statute? And a statute that would, under your theory, leave many violations beyond remedy.
Yes, well, I cited that case out of the Northern District of Illinois that said, in order to succeed on the ADA claim, the plaintiff must prove that an official who had authority to address the alleged discrimination.
That
and-
agrees with your conclusion.
Yes,
Take me from the statute.
how there would not be vicarious liability.
Right. As there is in virtually every other area of American law except 1983.
Right. I mean, like, I don't think the statute, it's kind of hard to prove I mean, I don't think the statute supports the vicarious liability. I don't
Do you
see
think it supports an award of damages?
the statute?
Yes.
Yes,
Okay. And no individual liability. So the only candidate is the city and the county. And where do we get this policy, custom, or widespread practice Monell standard out of the statute?
how do we get it out of the statute?
How do you?
Well, I mean, I don't know that there's a case where there has been vicarious liability with respect to police officers.
You're arguing more generally
Okay,
that under Title II of the ADA, there's no individual liability, and that institutional or enterprise liability should not be governed by respondeat superior, but instead by a Monell-like standard. I'm asking you for some affirmative indication, statutory text. I'll even take legislative history if you've got
Right.
it, okay? For working that standard rather than the kind of default respondeat superior liability standard into Title II.
I mean, what Judge Hamilton is getting at is what the courts have struggled with.
yes, and obviously I'm
Okay.
struggling with it.
Well, and it requires an interpretation, does it not, of the language in the statute that Congress used about the denial of benefits, services, programs, or activities of a public entity or being subjected to discrimination by such entity. And so what you have to answer is whether, as Judge Hamilton observes, the norm of being able to impute liability under principles of respondeat superior applies here, or whether that language signals some different congressional intent.
Well, I
I mean,
think
that's
it's a,
that's the question.
right. I mean, I would think it's a different congressional intent and that they didn't intend to allow there to be respondent superior liability under the ADA.
And then the question is why?
Because I don't see any language in the statute that supports that.
Well, okay, so let me give you an example. Suppose, for instance, that a police officer in the city of Fort Wayne acts directly contrary to a program that the department has in place through training to deal with mentally ill individuals that need emergency medical health treatment or assessment. And Officer John Doe just flagrantly violates that. Why isn't that the denial of the benefit of a program that the entity has in place, such that the city of Fort Wayne or its police department could be held responsible under the statutory language? Why not?
Well, in that scenario, I think there should be vicarious liability. If he flagrantly
hold on.
violates,
Okay, then,
Yeah.
all right. If Okay, so now we've identified a hypothetical, okay, where there may be vicarious liability. What's the legal principle for us as a court to determine when is there and when is there not?
Okay, in your example, you said that there was a program of the municipality that he violated.
Right, and the reason I made that hypothetical up is because I'm just looking at the statutory language.
Right. And I think in that case, if there is a program that the municipality has put in place and an officer violates their program and it violates the ADA or the Rehabilitation Act, there should be vicarious liability. And the reason I'm struggling with it is because there's no violation in our case, but I'm looking at your hypothetical, and I think the statute would support
Right,
vicarious
and
liability.
Right, and so we have to decide your case too, and we
Right.
will. But we've also got to be mindful of tomorrow's case and how to interpret the statute.
Right.
And we punted on it in Kane because it wasn't required to be
Right.
resolved in Kane.
And I guess I mean, I haven't really studied that particular issue in such that I can give the greatest answer, because in our case, I assume that the ADA applied, the Rehabilitation Act applied, and vicarious liability applied. But even in all those, with all that application, assuming that application, there's no violation here.
And I take it that you understand that what we are all trying to do here is to decide the contours and the limits of an ADA claim in the law enforcement context.
Yes.
Could I ask you a couple of questions about your cross appeal?
Yes.
The plaintiffs have asserted that the district judge did not address several grounds they offered for denying costs in the case. So it sounds like, and I would be interested in your thoughts, that if we were to vacate the denial of costs, we would have to send this back for another round of litigation in the district court over these costs?
Do I agree with that?
Yes.
No.
Why not?
Because, you know, first of all, the standard is abuse of discretion, and Mr. Culp lost on brought 7 claims against 7
The
defendants.
plaintiffs have said they offered several reasons that the district court did not address. Wouldn't we have to send it back for the district court to address those items?
My position is, I believe this court can reverse the district court without addressing those issues.
I understand your position.
Okay.
Okay. Can I ask, how much do you think has been devoted in attorney's fees to these $10,000 in costs
What are my attorney fees?
devoted to that issue so far?
I couldn't guess or speculate. I don't know. This case has been around for a few years, so how much of that, all of the attorney fees were devoted to this issue, I do not know.
The cost issue only arose after the final judgment.
We
It's all
petitioned-
the costs attributable to your cross appeal. So, okay. All right. If you don't want to tell me, I'll leave it at that. Or you can't tell me.
I just don't want to guess or speculate, because I would just be pulling a number out of the air.
Can the costs that are attributable to the claims of Carl Culp be separated from those as to Roberta Culp, such that an award can be made of costs solely attributable to Carl's claims that would not have also been incurred with respect to Roberta's claims?
Right. So as I stated in my affidavit, all of the are presented to the court. All of the costs that we incurred in this case were attributable to Mr. Culp. He claims substantial mental, emotional, financial damages from this case, and collecting all of his medical records and employment records was a significant part of the cost. The depositions, I think there were 7 or 8 depositions taken in this case. The only, I took the deposition of Mrs. Culp, which I would have taken anyway, because 1, she was a witness to the incident. 2, she's married to Mr. Culp, so I wanted to know what his mental and emotional condition was before the incident and after the incident. And the only claim of hers that went to trial was the pepper spray that got on her. And out of her 42-page deposition, only a half of her page was devoted to her claim.
Would
So-
you agree that with Judge Dow's analysis in the Ellis case, that an award of nominal damages does make somebody a prevailing party for purposes of costs?
I wouldn't agree with that because that was a Northern District case. It wouldn't be binding. And in his opinion, I cited.
Well, you want us to follow a lot of other district court opinions. I'm just asking about his analysis.
His
and his analysis of our precedent.
Well, in that case, the jury found that one officer used excessive force and the other officer didn't. And it
Let
was
me
the
go
plain-
back to my question.
Okay.
Do you agree or disagree, and if you disagree, why, that an award of nominal damages makes a party a prevailing party for purposes of a cost award?
I don't agree with that.
Why not?
Based on the case law, I cited a case in my brief, the Batts case, where the jury awarded $30,000 to the plaintiff, but they still awarded costs to the defendants and said the defendants were the prevailing party. So there's several cases that I have cited where there are more than nominal damages and the defendant was still determined to be the prevailing party for costs.
Okay, Batts is in Northern District of Indiana. Ellis is Northern District of Illinois. I'm asking for guidance on our law.
Okay. I have a Seventh Circuit case.
On nominal damages?
Let me see. Well, I guess I cited the Rivera v. City of Chicago case, which is a Seventh Circuit decision regarding the claim that the cults are indigent. And in that case, they said they still awarded costs and considered indigency one factor to consider. So that was the Seventh Circuit case I cited.
Okay, thank you.
Okay. Thank you.
All right. Thank you very much.
Thank you.
Judge Scudder, to your point about the hypothetical, it's not so hypothetical in that Whitney Woods is a crisis intervention trained officer to come to these sort of events, and he did behave in the manner he did. So I think there is an issue there for potentially vicarious issues to flow through. As far as the mental health component of this, we view the mental health component as its own separate disability that should have been accommodated at the time through de-escalation, not taking such a hostile, angry manner. I think one of the important things to think about, if you look at this scene, there was a mental health nurse. While the officers were in the car with Carl, that approached several times and said, "Can I help? Can I talk to him?" And this is a mental health professional that was on the scene and offering assistance, and that sort of accommodation could have changed the course of events drastically, I think. So I think the accommodations,
Hold on, Miss Grassley stayed in the parking lot, didn't she?
Miss Glassley did, but this is a lady named Danette Quartz. And Danette Quartz is a lady that came to the car while he was in there after the taser was deployed, and she said, "Can I talk to him? Can I talk to him?" And she's a mental health nurse, and she asked if she could call an ambulance. And then afterward, when he was laying on the ground, she came up again and said, "Can I help? Can I get him his wheelchair?" And so she was offering the police officers ways to accommodate, and she's a nurse there.
Okay,
So-
great. That's
how come-
wonderful that she was there. If you're in the police officer's shoes, you've got somebody who may well be a physical danger to himself and others. Do you allow a bystander to come in and try to help, who might wind up getting hurt herself?
Well, there's no allegation that he was a danger to others. The call that came out said that he had
They
a.
didn't know that at the time.
The-
They didn't know that. This woman could have been anyone. You can't just have stray people coming up saying, "Police, I am a mental health expert and I will help."
She
You,
wa-
you can't have that.
She was in scrubs, and the officers did direct her to call an ambulance. So anyway, I think there could have been minimal, reasonable accommodations that would have helped the mental health crisis from even escalating to the point that it did. And we would just respectfully request that you find that the ADA applies, and there could be very vicarious liability. And as to the issue of the cost, that's a hard hurdle to overcome. There's a lot of discretion there that trial court judges have, and the standards no reasonable fact finder would find differently. And I know in their case, they cited a case called Delta, but it also talks about a court may, when assessing costs, look at the parties' prior conduct or misconduct. And in this case, Fort Wayne was monetarily sanctioned during the discovery process for withholding, non-complying with discovery. And they actually tried to include some of those costs with non-compliance with discovery in their bill of cost.
Could you direct us to where do we see that?
I'm not going to be able to pull the record site, but it's in our argument.
You see, again, the reason I asked my question earlier is because your argument has focused on his physical disability, not a need to accommodate mental health issues.
Oh, we believe there was a need to accommodate mental health issues.
I know, but that hasn't been that really wasn't the thrust of your argument.
It, certainly in our allegations talking about diffusing time in our complaint, the ability to diffuse time and call upon other trained officers to intervene and help, that was about the mental component. I'm sorry, I'm out of time.
Don't be sorry. If you have anything to add, please do.
I appreciate being here, and I appreciate your thoughtful questions, and we hope that you find the ADA applies and Mr. Culp has a claim.
And we appreciate you.
Thank you.
And we also, of course, appreciate Ms. Trier. And thank you. And the case will be taken under advisement. Thank you very much. We're going to go on to the second case of the day, which is 23-2204, Blonde versus Kramer. Good morning, Mr. Heckman.
Good morning, Your Honor. May it please the court, Michael Heckman for plaintiff appellant Armin Wand. Mr. Wand's blindness and stutter, limited education and lack of legal experience, incarceration, and the stage and complexity of his claims all combined to profoundly hinder him from presenting his medical deliberate indifference and negligence claims to a jury. The district court's refusal to attempt to recruit counsel for Mr. Wand in light of these obstacles was an abuse of discretion twice over. First,
Now, if the district court had granted the request for a neutral expert, would that have been sufficient here? Or do you think the denial of appointment of counsel still would have been an abuse of discretion?
it still would have been an abuse of discretion. As we discussed in the briefs, a medical expert would have helped tremendously, but Mr. Wand still faced the difficulty of presenting his case to the jury. With his blindness and stutter, lack of education, inability to prepare his witnesses, he was simply incompetent to do so, with or without the expert. But the expert certainly would have helped. That's part of why the denial of counsel was so significant, because the court also denied the appointment of the neutral expert. Without any expert, Mr. Wand had no real shot to convince the jury that his uncontested symptoms, his 10 out of 10 pain, his inability to lie down, his vomiting 23 times in a night, his crying out in pain when Nurse Kramer pressed on his abdomen, he had no real chance to convince the jury that those indicated appendicitis, should have indicated appendicitis to a trained medical professional.
You're talking about as of the 13th.
As of the 13th, that's right, during that first visit.
Assuming consistent with his trial testimony, he did not indicate at that visit that he had lower right quadrant pain.
As Kramer now concedes, if the jury had believed that he had indicated lower right side pain, that would have been the ballgame. He would have won on that point. But even without that, certainly he attested several symptoms, both in his verified complaint, his deposition, and at trial in his testimony. Several symptoms that were very serious, and a medical expert could have testified that they would have put her on notice.
How do we know that?
Obviously, we haven't retained an expert here, and so the best place to look is other cases where experts have testified similarly. Rivera v. Kettle Moraine Correctional Institution is one case where a litigant had similar symptoms, somewhat different mix, but similar symptoms, and submitted an expert report where the expert said those symptoms would have put a nurse on notice, and ignoring them was deliberately indifferent.
Mr. Hegman, can I go back to one aspect of Judge Hamilton's comment and question? It seems to me that Mr. Wand's trial testimony, especially his acknowledgement on cross-examination about the 14th, that had major consequences in my view for his deliberate indifference claim. I don't see how, against the backdrop of that admission, it's even possible to win that claim. But he still could have prevailed on his negligence claim. You agree or disagree with me on the deliberate indifference claim? I just don't see what a lawyer could have done against the backdrop of that admission.
I disagree. I agree that he still could have won his negligence claim. Disagree that his deliberate indifference claim was doomed.
How? Because given the admission, my words, not yours, he and Nurse Kramer, they basically agreed on the fact pattern.
So I think one place to look is following that testimony, Nurse Kramer moved for a directed judgment, and the court denied it, saying it still could have been reasonable for the jury to find for Mr. Wand on his deliberate indifference claim, given the other symptoms. And of course, had counsel been present, the whole thing could have gone much differently. Mr. Wand had...
Can you articulate that for me, though? I mean,
how it could have gone differently?
I mean, how can a jury find deliberate indifference on that? I mean, you still have the negligence claim, and that's a serious question. I'll grant you that. But how in the world can he win that deliberate indifference claim?
With that testimony? So the standard for deliberate indifference is that Mr. Wand had an objectively serious medical condition that Kramer was deliberately indifferent to. Simple. So all Kramer needed was to be on notice of his condition and ignore it. Mr. Wand had several other symptoms, 10 out of 10 pain.
She inspected his abdomen area,
and he cried out in pain when she did so. He said he couldn't lie down. He said he vomited 23 times over the course of, I think an 8-hour span.
Okay, now go to the point you just made and then ignored it. But she didn't ignore any of that.
She didn't report Mr. Wan's serious condition to a doctor, which is the step that she would have taken had she, the step she should have taken, the step she took the next day on the 14th. Had counsel been present, of course, the whole thing could have looked very different, because Mr. Wan had said in many sworn statements and other filings before the court prior to trial that he did tell Kramer of his lower right side pain on the 13th. It's reasonably likely that counsel would have been able to elicit that testimony from him at trial. Counsel could have helped Mr. Wan prepare better for the rigors of cross-examination. If you look at the transcript, Mr. Wan seemed to struggle in response to the question.
I looked at the transcript and I don't see any sign of confusion. Maybe you can direct me to some.
So I think if you look right after this exchange, Mr. Wan pauses the cross-examination to ask the court for water, which I think could indicate that he was feeling overwhelmed. If you look above where this line of questioning started, there had been discussion of what Mr. Wan had put in his medical request form, and he acknowledges that in that form he didn't mention his lower right side pain, so he may have thought they were still talking about that.
Counsel went over that point because it was so important 2 or 3 times, and as I say, I don't see signs of ambiguity or confusion in that.
Well, certainly we acknowledge that it likely did not play well with the jury, as the district court said, and as Judge Scudder said, this made that path to victory significantly more difficult. As for why Mr. Wan, testified as he did, we don't have a firm answer, but I don't think this court can conclude that he just lied. He had under oath previously said twice that he had told Nurse Kramer this.
I don't know whether he was telling the truth or lying, but he was flatly contradicting himself on the key fact. And if we were to send this back for another trial with the assistance of counsel, he'd have a heck of a credibility problem on that critical point, don't you think?
Well, if he testified consistent with his sworn statements beforehand, he would have no issue. And there's reason to think that counsel would have.
He would now be impeached with his prior testimony from this trial, right?
There's, at least a reasonable likelihood that counsel would be able to clear up any confusion by asking him directly, what did you mean? What did you tell Nurse Kramer on the 13th? Is it in fact the case that you didn't tell her about the symptom? Assuming that Mr. Wan would testify.
So he's going to have to flatly contradict himself one way or the other. I mean, it's just he's in a very tough situation at this point.
He was in a very tough situation during this trial. He was managing for the very first time a whole trial with no legal education, not even a high school diploma. He was blind, has a severe stutter. He was in way over his head.
Go ahead and finish your thought.
I think there's at least a reasonable likelihood that the struggles he showed during cross-examination are related to his overall inability to manage this trial. And I will just remind the court that, again, this was just one path to victory. He had a second path to victory, his remaining symptoms, that an expert, easily could have testified, satisfied the standard at least for negligence and likely for deliberate indifference.
One of the points that you really emphasize in your brief is that he was relying before trial on jailhouse lawyers to help him, and I think you might be descriptively accurate, but I don't know that it was all that limiting to him. And here's why I say this, and you can tell me I'm right or wrong, is that he seems to have adequately, if not successfully, deposed on his own, pro se, Kramer and Johnson. So if his speech impediment and his blindness were really limiting to him, he managed to, he overcame that okay for purposes of that deposition. Because he's not hopelessly confused, he's not rambling on, it's not incoherent, there's nothing like that. And the question from the observation is, couldn't the district court have considered that among the remainder of everything else in deciding, all right, I might have to help him a little bit, he's got a speech impediment at trial, but I'm not going to expend the scarce resource of recruited counsel in this circumstance?
I believe that those depositions came after the district court's denial, and so they were not in front of the court.
All right. Forget that, but set that aside. I
In-
mean, he
in-
did okay in the depositions is my main point. It's not incoherent.
It's not incoherent. It's not great. There were questions left unasked. They were not particularly thorough or effective depositions. But he was able to do something, certainly. And at trial,
Sorry,
go ahead, Your Honor.
you finish your thought.
The other thing I was going to say, Judge Scudder, is that the district court, if it was going to say, relying on the couple of things I've seen from Mr. Wand, he is competent, it needed to disentangle that from the jailhouse lawyer's assistance. And this court has said that over and over. It's been very clear that the court has to explain its reasoning, and in particular has to explain when it's looking at competence, that it is looking specifically at the litigant's competence and not the competence of his jailhouse lawyers. That's cases like Henderson, DeWitt, and Walker.
I would like to follow up on Judge Scudder's question to you, please, because although the difficulties Wand experienced during the trial indicate, for me at any rate, a need for appointed counsel, should we consider that in assessing whether the district court abused its discretion in denying the request? In other words, okay, do we have to focus only on what was known to the court at the time of its decision, rather than on what took place later at the trial itself?
For purposes of the abuse analysis, you look at what was in front of the court at the time. Obviously, prejudice, you would look at what happened during trial. But everything that happened during trial was predictable from the time of the court's order. The court knew that Mr. Wand was blind, had a stutter, had no education, was incarcerated, had all of these issues, and the court could have anticipated the difficulties that he would face at trial.
I mean, would it be your view that, for instance, a deposition with just a few people there is a far less stressful situation than a full-blown trial?
Absolutely. In fact, in the trial transcript, the district court points out that when Mr. Wand got nervous, his stutter got worse. Certainly, the full trial experience in front of a jury made Mr. Wand much more nervous than a deposition would have. Thank you, Your Honor. I'll reserve the rest of my time.
Thank you very much, Mr. Heckman. Hello, Ms. Schmelzer.
Good morning, and may it please the court. I'm Jody Schmelzer, an Assistant Attorney General for the State of Wisconsin Department of Justice, and I represent the defendant appellee in this case, Nurse Becky Kramer. My argument, I'm first going to address how the district court did not abuse its discretion when it denied Mr. Wand his final request for recruitment of counsel. And then I will address how the denial of recruitment of counsel did not prejudice Mr. Wand given the jury's verdict and the testimony at trial. Of course, we start here with the premise that there is no constitutional or statutory right to the appointment of counsel in federal civil litigation. However, indigent civil litigants like Mr. Wand may ask the district court to request an attorney to represent him pro bono. This puts district courts in a difficult position of having determined of the numerous people lacking counsel who needs it the most. For example, in the Western District of Wisconsin, there are approximately 300 new cases a year brought by pro se litigants, most of them inmates, and only about 25 attorneys willing to take voluntary appointments, most of which won't even take one of those cases a year. The court just doesn't have enough attorneys to go around, so these requests are carefully scrutinized and subject to the abuse of discretion standard.
Here's my problem. Although the district court considered Wand's physical limitations on their own, Did the court ever consider the combination of his physical limitations, his educational attainment, and the difficulty of the case in combination? And if your answer is going to be yes, I would appreciate your telling me where I could find that. And if your answer is going to be no, isn't that required in determining whether appointment of counsel should be granted?
I think because Mr. Wand here had repeatedly requested the appointment of counsel, the district court has adequately addressed all of his professed impediments here. His limited.
Yes, but where will I find that? That's what I want to know.
The district court, I think, thoroughly addressed in his second and third motions for recruitment of counsel his limited education, his legal experience, as well as the complexity of the case and the fact that it involves medical issues. There it noted that nearly all pro se inmates are untrained in the law. Many have claims concerning medical issues, and there's no categorical rule that inmates with medical claims are entitled to counsel. It also found...
I don't see where the court ever really grappled with the problem as a whole, not just whether his physical challenges were debilitating or his educational level problematic, but whether, given those challenges, he would not be able to conduct the trial, particularly in the light of the need for expert testimony.
And I think here, Your Honor, these the claims that he made in his earlier requests for appointment of counsel were adequately addressed, and that's not going to change throughout the rest of his request. That and the court's finding that he advocated well for himself and that he was capable of litigating the case without an attorney. He was familiar and did state he had read the federal rules, the applicable federal rules. He was able to track his filings and deadlines, and he filed in this case, I think it was 28 pretrial motions before summary judgment was decided. So the court made those findings in its earlier decisions on his recruitment of counsel, and then focused more specifically, I think, on the vision and speech impairments that he raised later that it hadn't addressed before, and the fact that he had stated that he relied on jailhouse lawyers that he hadn't stated before. So it focused on those newer, impairments that Mr. Wand had raised in its final decision and its decision on the motion to reconsider denial of recruitment of counsel in that final request.
Ms. Schmelzer, can I ask you an aspect of, I think, what's at least what I hear is embedded in Judge Rovner's question? There's a point in the litigation when mediation or settlement discussions were being pursued, and there was a lawyer appointed at that particular stage. And one of the observations, correct me if I'm mistaken, that the district judge made was that the lawyer could not only help with mediation, but the lawyer could help with expert issues that may inform the pricing or the value of the case, or whatever the words were that were used there. And then when we come to the request to recruit counsel for trial, all of a sudden the consideration of a need for expert testimony drops out of the district court's analysis. And if you were to ask me, is it more important to have an expert for mediation purposes or for trial purposes on these claims? I would tell you trial 8 days a week.
In general, I would say yes, but here we're looking at the exercise of discretion here. The court made an initial determination when it granted his request for appointment of counsel, but it did so and noting that he still advocated well for himself, that
No,
he
that's
was
all.
ably.
That's all fair, right? I'm focused, maybe overly. Maybe you'll tell me too narrowly, but I'm focused on the expert because and you heard the colloquy that I had with Mr. Heckman about, the admission that was made on cross-examination. I think that's a major problem, definitely for a future trial, as Judge Hamilton's pointing out. I think it's a major problem in this case on the deliberate indifference claim. But the absence of an expert to identify the standard of care that Nurse Kramer should have been operating under on the 13th is a real, that's a big issue for him on succeeding on that negligence claim at trial here. Am I wrong about that?
I think you're partially wrong, Your Honor, with all due respect.
No, yeah,
Here we
convince me.
have a case where Nurse Kramer, it was stipulated, it was admitted that if he would have said, I have lower right quadrant pain in my abdomen, and shown some of those signs that he showed on the 14th, she would have sent him out, or at the very least called the healthcare provider, and he would have been at the hospital.
Right, but his negligence claim is that a nurse presented with what he presented on the 13th, not on the 13th, what he actually presented with, would have detected that he may have an emerging burst appendix or an appendicitis condition.
And I think if we accept that, we're going to then have a categorical rule that any time a pro se litigant brings a state law negligence claim, we're going to have to appoint counsel. And this court has repeatedly rejected that kind of categorical rule.
I'm not sure that the slope is that slippery.
I don't think so. Miss Schmelzer, here's something that worried me is that, okay, in asserting that one could try to obtain expert testimony by cross-examining Nurse Kramer, and that the court would treat her as an adverse witness, did the court ever consider whether Juan's limited education, his legal blindness, his speech impairment would limit the viability of that option? I mean, wouldn't that be a difficult means of obtaining supportive testimony, even for an experienced attorney?
This court has said that just because, and this was in Johnson v. Doty, a case cited in my brief, that just because a pro se inmate in a medical claim is denied an expert, that is not a reason to find an abuse of discretion here. That just because counsel could have added opportunities to improve the case doesn't mean the case was overly complex for the inmate to try himself. And we have to look here at what he actually was able to accomplish at trial. He asked and successfully deposed the two defendants in this case. He also cross-examined and impeached Nurse Kramer with part of that deposition testimony. This court has already, and this panel has already found that his speech impediment and his vision impairment did not make the case overly complex for him to try his Eighth Amendment claim against Officer Johnson. So we can't.
I'm sorry, say that again.
Yes, in the court's first decision in this case, it affirmed the denial of recruitment of counsel for his Eighth Amendment claim against Officer Johnson. He had those same vision impairments and the same speech impediment. In the trial with Officer Johnson, it was tried together. And in fact, the jury instruction for both Officer Johnson and Nurse Kramer on that Eighth Amendment claim was the same. So we really have to look beyond that, I think, and look at how did this prejudice Mr. Wand here. And I think to say that an expert could have been retained to support his claim that reports of stomach pain, 10 out of 10 pain, and vomiting all night was was violated the standard of care to not then consult the healthcare provider, I think that's a stretch. That's speculation. We have no reasonable likelihood that that could
I don't have
even
any
been
idea
made.
whether it is or isn't. That's
Right.
difficult. I don't know. I mean, you can say it, I can say it, but what difference does it make? We're not medically trained.
You're exactly right, Your Honor, and it's Mr. Wan's burden to show that counsel would have, there was a reasonable likelihood that counsel would have changed the outcome of this trial. We don't know that an expert could have even been retained to say that. There's no medical evidence, there's no treatises, there's no nothing here.
What's your recollection of what Nurse Kramer testified to at trial regarding the standard of care?
We know that the nursing protocols for the Wisconsin Department of Corrections Bureau of Health Services were introduced. That her nursing notes followed that protocol, and that there was no dispute that she did not deter from that protocol.
That's this business. That's like this chart thing.
That's correct, Your Honor.
Exhibit 505. Okay.
That's correct. And we also know that from the testimony of Jalinda Waterman, who was the health services manager there, that those protocols that's what our nursing staffs are instructed to follow. So she did follow that. We also know, and like I stated earlier, she conceded that had she been notified that he was having lower right quadrant pain, or even that his abdomen was distended, or that there was rebound pain, those symptoms would have required her, under the standards of care, to consult with a healthcare provider and probably go to the hospital after that. That those
Now, the district court based its denial of appointed counsel in part on its conclusion that expert testimony wasn't necessarily needed because recruited counsel declined to pursue an expert further. But the court recruited counsel only for purposes of mediation. So, do we know whether the recruited counsel for mediation ever made any determination as to the need for expert testimony if the case proceeded to trial? And if so, I would appreciate knowing where I would find that in the record.
That is not in the record. The only indication we have in the record of what recruited counsel did was a statement from the DOJ attorney during one of the pretrial conferences that Mr. Wan did in fact have qualified, experienced attorneys appointed to help him in mediation. They were not able to locate an expert and they got off the case. So that was the only thing that we say. There's nothing from the court in its decision or anything from Attorney Eisenberg in the record as to what his efforts were. But we know he was appointed for purposes of mediation and an obligation.
But then how can the district court base its denial of appointed counsel in part on some conclusion that there was no expert testimony needed because recruited counsel declined to pursue an expert? I'm a little concerned about that.
I see my time is up, Your Honor. If I could just finish
Of
and answer your
course.
question. I think the district court's decision was far more expansive than that. It said it reconsidered its earlier decision that expert testimony was needed in the case. And it wasn't based on the fact that that earlier appointed counsel asked to be withdrawn from the case. He looked at whether or not it was actually needed because was this in fact a credibility determination? And that the most crucial evidence was what he told Nurse Kramer on February 13th. And that Wan could cross-examine her about that interaction, and he did. The court also noted that that Mr. Wan may challenge and elicit expert testimony from Kramer, and we know that Mr. Wan attempted to do that. He subpoenaed 2 outside nurses and he also had Nurse Kramer, and this court tells us that that's not improper for the district court to rely on. In Winger versus Pierce,
But they refused to testify. the two nurses. They didn't respond to him.
Right. And again, we have whether or not that actually prejudiced Mr. Wan here. It's complete speculation to say an expert would have supported him in this case, or that it was reasonably likely that an expert could have been retained and supported him given his testimony in this case.
Judge Robner, can I ask one follow-up question?
Or you may ask 100.
So that point you just made, Ms. Schmelzer, are you saying that on appeal then, because it didn't happen at trial, right? There's no on appeal, is Mr. Heckman or whoever sitting in that chair in the next appeal, okay, is he obligated to make the standard of care proffer on appeal? Because if there's no expert on standard of care at the trial level, you're always going to say what you just said, and understandably so. Speculation. Okay, so then the question is, well, when is the standard of care considered for purposes of a prejudice analysis?
And just say it's not just me saying that. This court said that in Johnson v. Doty. But I think there has to be something in the record to bring this out of the realm of speculation and into what's reasonably likely to make a difference in the outcome of this case. That's the standard for prejudice here. And if there's nothing either in the trial court, there's no medical treatises, there's no any information submitted throughout the record that the signs of 10 out of 10 pain and vomiting and
Right.
Nausea should have alerted someone to appendicitis.
So my final question is this. Mr. Heckman, I think, is going to say, that's my point. That's the point. That's where a lawyer comes in.
And we don't have a categorical rule that lawyers have to be appointed to show that evidence. And we've seen pro se inmates bring that evidence in all the time in a record. We see that all the time in summary judgment. And I'd also note that the Rivera case, the inmate did present with lower right quadrant or holding his right side of his abdomen, and did note that it was his appendix to the nurse in that case, making it distinguishable here. And we also could have case law that says, and I agree with Mr. Wan, that we could have case law that says this should have alerted someone that he should have been sent out to the institution, or a summary judgment was survived in the situation where it's 10 out of 10 pain and he's been vomiting all night and has nausea, and that's it. If there's a case that says that, I think that meets that reasonable likelihood prejudice standard. But we have nothing like that in this case.
Could I just quickly follow up? The recruited counsel for mediation, was that Mr. Eisenberg?
It was, correct.
Was it Stephen?
Stephen Eisenberg,
Okay, I
correct,
guess
Your
there are
Honor.
two Eisenbergs in Madison. Thank you.
Right.
Okay, thank you.
Thank you, Your Honors.
Thank you. Okay.
Just a few
Mr.
quick
Heck.
points. Your
No.
Honor.
Can you hold on for a second? Please give Mr. Heckman the full 3 minutes that he requested. Okay.
Thank you, Your Honor. Judge Scudder, as you said, that is the point. Mr. Wan did not have counsel to put in this evidence. Mr. Wan could not do so himself. He was left without an expert to testify on his behalf. And there is reason to think that would have made a difference. Take Rivera, which is a fairly similar context. My friend noted that the plaintiff in Rivera did say it was near his appendix. Mr. Wand, in his verified complaint did say that. But also, even at trial, there was discussion that he had told Nurse Kramer that something was wrong internally, that it wasn't the stomach flu or something to that effect. And even with Mr. Wand's muddled testimony that was so damaging to his trial, the jury still deliberated for 2.5 hours in a 3-day trial. It took it very seriously. This case looked close. There is reason to think that an expert testifying on his behalf could have tipped the scales. And certainly there's reason to think that counsel would have been able to get an expert where Mr. Wan failed. Mr. Wan sent 21 letters out to doctors seeking an expert to testify on his behalf. 20 ignored him, 1 responded, and the prison screened it, so he never received that letter. Further harm from his incarceration. Counsel would likely have had relationships with medical experts, would at least have been able to get someone on the phone, and would have been able to get someone to come and testify to the standard of care. Whether it would have gone, as far as I would like here, as we've discussed, it's hard to know, but certainly there would have been something an expert could have said that likely would have been helpful in tipping the scales of this case the jury took so seriously. Also note that the district court continued to think that there may be some reason to have an expert. In its footnote, it noted it would provide funding for an expert, or it would consider providing funding for an expert if Mr. Wan could find one. Seems to be taking it seriously there. A few other notes. To confirm, the Kramer and Johnson depositions did occur after the denial, so those were not part of the court's consideration. On this court's prior decision in the appeal before this one, the Johnson claim, this court said it was doomed, so it didn't, Mr. Wan couldn't have succeeded regardless of his competency there. My friend referenced the testimony of Jolinda Waterman. That is the testimony that veered into expert, that the district court chastised opposing counsel for veering into expert testimony elicited from Ms. Waterman. Had Wan been represented by counsel, counsel would have objected at the proper time. Mr. Wan tried to object later and was told by the district court that he had done so too late, that the objection had needed to be contemporaneous. Further evidence of Mr. Wan's incompetence in managing that trial. As for Mr. Eisenberg, whether he investigated experts, we have Mr. Wan's declaration saying, previous counsel appointed my case neither sought an expert to assist me nor aided me in any way. That is evidence on the record, Mr. Wan's declaration, R237. The question is, who needs counsel the most? Mr. Wan certainly needed counsel to assist him in this case. We ask this court to reverse the district court's denial of counsel, remand for the recruitment of counsel, and a new trial. Thank you.
Would you stay there for a moment
Certainly.
while we thank you? Thank you so much for taking the appointment and for doing such a terrific job for your client. And I absolutely as well want to thank Ms. Schmelzer, who did a terrific job for her client as well. You're both in the finest traditions of what we hope for in lawyers. So thank you to both. And the case will be taken under advisement. And we're going to take a 10-minute break. Okay? Thank you. All right. Thank you very much. We're going to go on to case number 3, 232301. Reginald Pittman versus Madison County, Illinois. And is Mr. Anderson.
That's correct.
Good morning, Mr. Anderson.
Good morning, Your Honor. I didn't mean to interrupt.
No, you didn't. Go ahead.
I am Ross Anderson here for plaintiff Reginald Pittman, and may it please the court. At 9:30 p.m. on December 19, 2007, plaintiff Reginald Pittman, a pretrial detainee in the Madison County Jail, used a blanket to hang himself from the bars of his cell. Plaintiff was in a 2-cell segregation unit because it had bedclothes and clothing from which a noose could be made, because it had a crossbar, and because it had a fixed stool from which plaintiff could stand. It provided the perfect instruments from which plaintiff could hang himself, and it was not an appropriate cell for protecting plaintiff from self-harm. There were available suicide prevention cells at the time of plaintiff's suicide attempt. Compounding the danger presented by his cell, he was in a 2-cell segregation unit that was separated from the rest of the jail by a door and a small window, and his cell was off to the side so it could not be viewed when making rounds through that door. Plaintiff's suicide attempt resulted in asphyxia and severe brain damage. The primary evidence in this case concerning the suicide attempt and the events leading up to it and the conduct of the defendants came from the other detainee in that 2-cell segregation unit, a witness named Bradley Banavies. In a recorded interview that took place approximately 2 hours after the event, Bradley Banavies stated that 5 days before the event, on Friday, December 14, the plaintiff asked defendant jail deputy Matthew Werner to arrange for a crisis referral. It was a Friday evening. Crisis was not on the premises. Defendant Deputy Werner, according to Banavies, did not take plaintiff seriously. Werner promised plaintiff that he would put his name on the crisis list on Monday, the following Monday.
Mr. Anderson?
Yes.
Yes.
As I understand, we're familiar with the tragic facts of this case in general. We know it's been tried 3 times.
Correct.
Right. As I understand it, the only issue on appeal is one of the jury instructions.
That's correct.
So could we focus on that, and could you tell me what you believe the material differences are between the key instruction given at the 3rd trial and the portions that were approved in our last decision in this appeal and the instruction given in this trial?
Yes, sir, and those key differences focus on basically the instruction given in this trial focuses on the result, and the cases that have now changed the law, in this case Miranda.
Sorry, could you point me to the language you're focusing on?
I am focusing primarily on paragraph 2 of the instructions, and
Yeah. You see the challenge language in sections 1 and 2 of the jury instruction seems certainly to be nearly identical to the language that was approved in that instruction in Pittman 3 against a challenge based on Miranda and Kingsley. Why then doesn't the law of the case doctrine apply such that we shouldn't consider the challenge?
because they are not in critical point identical, Judge. In these paragraph 2, I think absolutely makes this a reintroduction of the subjective intent that the court disapproved in Pittman. In paragraph 2, it requires that there be a finding that defendant Eaton and Warner were aware of a strong likelihood that the plaintiff would seriously harm himself or strongly suspected facts showing that strong likelihood. In the first instance, and
Okay, here's our problem. That language was used in the trial that led to Pittman 3.
correct.
You challenged it then. We approved that language but reversed on paragraph 3. Correct?
Right.
Correct as to the first prong only. And if the court will look at Kingsley, what Kingsley had to say,
Okay.
No, let's, yeah.
What I'm trying to, you seem to be wanting to say Pittman 3 was wrong.
no. Because
Okay.
if you
Or
read,
contradicted itself.
if you look at the exact language, it said that the jury may on the first prong, and I'm looking at page 827 through 828, were aware of or strongly suspected facts, and that the language that they were approved goes to the first inquiry whether the defendants acted personally, knowingly, or perhaps even recklessly, and whether their actions would lead to harmful results. That is not what, that is what is in my instruction. That is not what is in the court's instruction. What is in the court's instruction is that they must be aware of the strong likelihood that the plaintiff would seriously harm himself. That is exactly a subjective standard that at the time that they took the actions to deny.
It's hard to see a material difference, though.
Yes,
Yeah.
I think it's an absolutely, and I think it makes all the difference, Judge, because it's now Eighth Amendment. They have to know that he's going to kill himself, or that they have to know that there is going to be a suicide attempt when they deny or strongly suspect facts that support it. Every piece of evidence in this case is that this conduct was miserable. You cannot delay till Monday. You cannot not put him in a modesty suit if you do delay. You cannot not protect his surroundings. You cannot fail to take an action if you believe there's going to be suicide. His superintendent said if he did these things, he should be fired.
Weren't the arguments that were raised in this appeal equally available in Pittman 3? I mean, why should we consider a challenge to the jury instruction if it could have been raised in the last challenge to the same instruction?
Because in this case, and while I did, you're correct, Your Honor, I cited the Ninth Circuit pattern jury instruction, but the issue here, in fact, the issue in all of these pertinent cases has to do with the extended period of time that the individual is undergoing problems before they try to kill himself. In Miranda, it was a starvation issue. In Gordon, it was long-term consequences of drug use. In our case, it's a 5-day period of time where he has been denied treatment, where he has been denied referral to crisis, where he has not been put into protective custody, and where he has again been denied and he's been given bad news. Over that time period of time is the period of time where almost certainly he decided to commit suicide. He was seeking help before. He wanted to have crisis. To say that he knew at the time, or they were aware of the strong likelihood that he's going to commit suicide, is simply not supported by the facts. They quoted, and his argument, John did a very nice job of quoting my expert, and saying my expert says determining whether there's actual suicide risk is like, and there's going to be suicide is like predicting the weather. But these actions are terrible. And each one of them increases and creates a substantial risk of harm. That, and I pointed out to the court in the first trial, because the first trial was trialed under a federal failure to provide medical needs, that was exactly what was given to the jury, and the jury wrangled with this case, and they wanted the evidence in the videotape, which was kept out at that time, and they almost hung up. They actually advised the court that they were hung up at one point. And so a very different situation to have to prove, and I don't think you can prove that in any suicide case, that they knew or that there was a strong likelihood that he's going to commit suicide, particularly where he is requesting assistance or counseling. And that's effective stuff under all the evidence in the case. So I think it's substantially different. I don't believe that it's the same issue that was presented because, frankly, I walked into this trial believing that the very language, and I raised heck about it in trial too, that the very language in Pittman and under the series of cases was that the first prong was limited to the act of the defendant that substantially increased the risk.
I hear you, but I haven't yet heard an answer to my question.
All right, well, please, I did not mean to not answer.
I'm looking at the same paragraph in the 2020 Pittman opinion by then Circuit Judge Barrett. End of page 827, start of 828.
Right.
First part of that paragraph. Pittman's argument fails as to the instruction that the jury decide whether the defendants, quote, were aware of or strongly suspected facts showing a strong likelihood that Pittman would harm himself. In essence, the challenge language accurately conveyed the correct legal standard to the jury. That looks like the key language in paragraph 2 as given in this trial that you're telling us was wrong.
But the
What is wrong about this?
The last part of that sentence also goes on to say, the standard to the jury if the defendants were aware that their actions would be harmful. And in this case, that is not there. What it says is that the defendants were aware of the strong likelihood that the defendant would seriously harm himself. And the distinction is set out, I think, very nicely by contrasting the Ninth Circuit opinion or Ninth Circuit proposed, or actually instruction now, that they made an intentional decision with respect to the conditions under which the defendant was confined. That's what they did. And they put him at substantial risk. The substantial risk standard was also used in the first trial, and that made all the difference in the response to the jury. He didn't decide to catch
I'm going to try one more time.
All right.
Point me to the material difference between the instruction approved, the portions of the instruction approved in Pittman 3 in 2020 and the instruction given here.
I only am relying on the language in the opinion which limits that operation to their actions. What happens here in paragraph 2 states that they were aware of the strong likelihood that he would seriously harm himself, period. And it doesn't limit it to what Kingsley says or what Miranda says, which has to do with the first prong is limited to the acts of the defendant.
If you want to argue that Pittman 3 was wrong, I would understand your argument.
All right.
I don't understand an argument that says it's right and that the district court failed to follow it here.
Well, Your Honor, I appreciate that. And if indeed it's not limited to the very acts that we're talking about, and it's not limited to the idea that you are substantially increasing risk, because that's what was done here. Each one of these actions substantially increased the risk to the plaintiff. Failure to refer did it twice. Didn't provide medical care, according to the expert testimony, lowered his self-esteem and created a separate suicide risk. The other actions, failure to protect, all of those things put him in the wrong environment. All of those things, each substantially increased
Mr. Anderson, can I?
So, and it made a difference because that was also substantial risk was in the first trial.
Mr. Anderson, can I ask you a question here?
Sure, please.
Okay. Taking Judge Hamilton up on his offer, okay? Courts make mistakes. Did we make a mistake in Pittman 3?
Honestly, in my heart of hearts, I think so, yes.
Okay, then that's a different point.
All right, you're right.
Okay, that's a different point. Okay, and why or where?
Because objectively, it is now an objective standard. And what has to be done, if you are actually operating in an objective standard, and you say that the defendants must know that there is a substantial likelihood of self-harm, which is essentially a suicide attempt, at the time that you're intervening, what you have done is you have introduced a subjective element into what is necessary to find liability.
Okay, now, I think the reason that the courts around the country are having a heck of a time with this, okay, we're not the only one. We got a bunch, I mean, you're focused on the Ninth Circuit, I get it, but we have other cases. We have Kemp, we have Thomas, we have 2 other pending appeals that are dealing with this issue, okay? Courts around the country are struggling with it. Why? In my view, because of confusion about how to apply Kingsley Step 1. You know what I mean?
Absolutely.
Okay. And so, in your view, if you had a blank piece of paper and you could say, forget all this precedent, what does a plaintiff need to prove under Kingsley Step 1 if it's properly stated in your view?
In my view, they must prove, and it could be just exactly as Judge Coney Barrett said, it can be any of a number of standards, but they must prove that there is an intentional decision that was made with respect to the elements of confinement or the failure to deny treatment that substantially, objectively increase the risk of suicide to the plaintiff.
Right. And so would you agree that that means essentially non-accidental conduct?
Non-accidental is
all I'm doing is trying to say, so in Kingsley, the court gave the example. Kingsley's an excessive force case.
Correct.
Okay, so Kingsley gave the example of 2 instances where there would not be knowing or intentional conduct. One, a taser accidentally goes off and tases somebody, but the officer did not pull the trigger or whatever you do to get a taser to go off. Okay, and number 2, an officer stumbles while walking, trips and falls on somebody and hurts them. Okay, those are the 2 examples that are given in Kingsley. So this is a different case. This is an excessive force.
Right.
So take Kingsley and translate it here, setting aside our precedent. What does it require?
It requires that somebody, and in this case there has to be objective evidence, somebody violates those rules and standards of objective evidence or standards of conduct and does so in a reckless or deliberately intent way, and that their act does this and they know or should know that it increases the risk of suicide substantially. You don't have to know that he's going to commit suicide. And that is my entire point. Here, this instruction says that you must, and I'll turn to it, be aware of the strong likelihood that plaintiff would seriously harm himself or strongly suspect facts showing a strong likelihood. The evidence in this case is that over time he kept requesting to see crisis and wondering why the crisis lady wasn't here. This went on for days. On Tuesday, 4 days later, he asked Defendant Sergeant Randy Eaton, "Where's the crisis lady? Why haven't I seen the crisis lady?" And Eaton again promised him that he's going to put the guy in for crisis. These are intentional acts or reckless acts, because if you don't give a person in solitary, protect them, give them access to counseling, put them in a protective environment, and leave them there with all of this stuff that can be used as a hanging device, which everybody in the case, I don't know if it's jumping off the page, but everybody in the case says that's not even close. You don't do that with somebody who is requesting crisis and then give bad news. And the evidence is clear that by Wednesday, he's had enough. So he writes a suicide note at that point. And in that note, he says the guards are effing with him. In that note, he says that he apologizes for what he does. And if the court will give me a second, I want to turn to the exact language of the note. Well, I hope I can turn the exact language of the note. I may have to rely on my. Here we go. He says specifically, I tried to see the crisis lady, but they ain't let me. I told them, period. No one listened to me. Now, this is something that he has done over time, and it's very clear, and I think virtually the only interpretation under this evidence is that they denied this on Friday. He kept asking about it. They didn't promised it him again. And by the way, promising that you're going to do this also carries and creates an independent suicide risk. And by all of the expert testimony. And they did that, and then he writes, I tried to see the crisis list, but they ain't let me. I told them, no one listened to me. And from a causation perspective, Dr. Kahn, who as part of his career does something that he is a quality insurance autopsy of facts to determine causation and whether failure to adhere to policy and procedure actually causes things. And he has said that he has never seen such a clear case of causation in the thousands of cases he has done this medical autopsy on. And I see I've just used up my time, so
Yeah, well.
That was a while ago.
That was quite a while ago, but that's okay.
I apologize, Your Honor.
Oh, there's
my
nothing
ex-wife's criticisms of me, Your Honor, are probably correct. So.
No. Did you say your ex?
I said my ex-wife said I talk too much.
Do you have a new one?
At any rate, I thank the court for listening.
Thank you. Hello, Mr. Gilbert.
Good morning, Judge, and good morning, Your Honors. May it please the court. I'm John Gilbert, counsel for the appellees. As this court will not be surprised that my argument is that this court's decision in August of 2020 gave us a roadmap for retrial. And I am happy to say that we followed that roadmap in the third trial of this case. Judge Dugan?
Yeah, let me ask you this.
Sure.
Because the law of the case doctrine is not jurisdictional, it doesn't deprive us of the power to consider the issue that was raised here. In your view, has there been any intervening change in the law or other extraordinary circumstance that would weigh in favor of our reconsidering the jury instruction challenge?
Your Honor, I do not believe so. And none was cited by Mr. Anderson in his brief or his argument. As this court stated, in Pittman 3, the final sentence of the opinion deals with the law of the case doctrine, in which the court says, a ruling made in an earlier phase of litigation controls the later phases unless a good reason is shown to depart from it. And I'm certainly not aware, and it hasn't been brought to the court's attention, that either this court or the U.S. Supreme Court has changed the legal standards that were enunciated and adopted by this court in Miranda. Excuse me, and in Pittman 3, excuse me, as this court has already recognized in its questioning of Mr. Anderson, the court says the exact wording that is now being challenged failed. And the court indicated to us that there are, the two prongs of Miranda are taken into consideration. The first prong, as the court said, was satisfied by that language about defendants were aware of or strongly suspected facts showing a strong likelihood that Pittman would harm himself. And I think where, with all due respect, I think where Mr. Anderson might be conflating a subjective element with just the requirement in Miranda that the jail officers had to know something. You know, you can't, it's a two-part test. You don't get to the objective reasonable part until you're able to show that they at least had knowledge of something, of objective facts that somehow showed that their actions, as the court said in Pittman 3, would lead to harmful results. It's not a subjective element. And I don't think that the instruction or this court's opinion in Pittman 3 said that at all. It approved, as the court has already recognized, the exact language that we used in instruction number 19. And Judge Dugan, in our view, was right to do that because, as I said, I always took Pittman 3 as a roadmap for the retrial of the case. It was retried on the same evidence. Every other jury instruction was the same. We removed the one word that this court advised us was wrong in that instruction in the second trial. And in our view, the third trial was essentially flawless because the same evidence went before the jury. The jury instruction was approved by this court in Pittman 3, and the jury ruled in our favor once again. And I think that, you know, the emphasis that Mr. Anderson was putting on the facts is sort of a distraction because the facts, that was the jury's realm. We're here only on this jury instruction. And in fact, Judge Scudder's question I thought was pretty incisive about, and Judge Hamilton too mentioned this, that are you saying we were wrong in Pittman 3? Well, of course, I don't think so, but there's also a procedural issue there. That wasn't raised by the plaintiff either in his briefing or in the court below. And so our position would be that that's forfeited because never was there an argument that this court was wrongly decided Pittman 3. So I think
Mr. Gilbert, your argument's clear. I mean, it's clear in your brief.
Yeah.
You're articulating it clearly in the courtroom. Can you just step back for a second? And,
sure.
And you know Kingsley. You've read Kingsley as many times as we have, as many times as Mr. Anderson has. What do you make of Kingsley Step 1 in a case like this outside of the excessive force context? So you have a medical care case, right? That's what this is.
Right.
Okay. How do you apply it? I think this is what courts are struggling with around the country.
Well, I think this court...
Because you can't have liability for non-knowing,
Exactly.
non-conscious, non-intentional conduct. I mean, you can't impose 1983 liability.
And that's
So I
how
think that
interpret
explains the existence of Kingsley Prong 1.
Right.
And then the question is, how does it apply outside of the excessive force context?
Well, I think the way it applies outside the excessive force context is that the defendants, as in this case, have to know or at least have reason to know of facts that would indicate or suggest that the plaintiff was at risk of harm. And that's how I see that applying. And again, I don't think it's a subjective element. It's that you can't, it's almost like saying, well, I can't be liable. You gave a pretty good hypothetical when Mr. Anderson was arguing. If I am a police officer, well, that's excessive force. But if I'm a jail officer, and I have, and it's interesting.
I'll give you an example. I'll give you one that works.
Okay. Good.
Okay. Here we're focused on 2 correctional officers, right? In particular. Suppose we're focused on a third, and let's call him John Doe. Okay. And he was working in an entirely different area of the jail, right? he doesn't have any idea who Mr. Pittman is, anything like that, right? So if you go through the Kingsley analysis there and you say John Doe 2 is responsible for the failure to provide medical care, Mr. Doe is going to come in and say, I can't possibly be liable. I had no knowledge and I did nothing to create the conditions, right, that presented a risk to Mr. Pittman because I was working on the 5th floor and all this happened on the 1st floor or whatever. Now that's a straw man because it's a little too easy.
But I think you're right.
I mean, that's an example.
But I think you're right, Judge, because you can't hold someone liable under the Fourth Amendment standard from Kingsley unless they at least have knowledge of the facts that then enables you to go to the next step of the analysis of did they take objectively reasonable measures or not? Because if they're not aware...
You know about our decision in a case called Kemp versus Fulton County. Does that ring any bell?
I'm sure I've read it, but it doesn't come to mind at this
All right.
point.
I mean, Kemp is a failure to protect context. It's different than this, but not too different. And we rejected the contention there that a plaintiff must prove that the defendant was subjectively aware of a substantial risk of serious injury.
And I don't
Okay.
disagree with that. I think the difference is that there, to me, and I think this is what the current state of the law might be suggesting, is that you don't have to have subjective awareness of a risk, but at a minimum, you have to have knowledge of facts that then require the next step to the objective reasonableness analysis.
Okay, can you pause right there? Just pause right there, okay? Because this is where I think the issue is joined. Okay, because if what you said is correct, now go to the instruction that was given. Step 2.
Yes.
Eaton and Werner were aware of this strong likelihood that plaintiff Pittman would seriously harm himself or stop, because it's or.
Yeah.
Okay, now take what you just said and square it with that.
Okay. It's the way I would square it, Your Honor, is that it's like any other issue in the law. You can't have liability unless a defendant has knowledge of the potential for harm, if you will. So, for example, in Pittman 3, the court says, if the defendants were aware that their actions would be harmful, then they acted purposefully or knowingly. If they were not necessarily aware, but nonetheless strongly suspected, then they acted recklessly. This much is inconsistent with Miranda. And what I think, and maybe I'm not articulating as well as I could, but I think that in order to have liability, there has to be at least a minimum knowledge that what you're doing or not doing places someone in harm's way. Because for example, Mr. Anderson.
I think you're doing a fine job. This is where the federal judiciary is tongue-tied on this.
I know, and certainly we could argue this all day long, and different courts differ. But a good example, I think, is when Mr. Anderson talked about the suicide note. There's actually, the evidence in the case is the guards were not aware of the suicide.
Well, that came later in the timeline, right?
Yeah, it came. Well, according to the testimony, he wrote the note time of days before he committed suicide or attempted suicide. In fact, his cellmate, if you will, Mr. Banavies, I think we were able to show was aware of the contents in the note, and he didn't do anything. But again, if they don't know about the request. Of course, that was a fact question, which I think the jury resolved, as to whether or not he actually asked the officers who were sued for crisis intervention. That was never proved. That was an allegation. And in the suicide note itself, he says, they won't let me, never identifies who. But getting back to the conundrum that we have in the state of the case law, I would still argue that to satisfy Kingsley, there still has to be some modicum of knowledge, whether it's new or should have known or suspect, before you can set someone up for liability and then move to determine whether or not, based on what they knew, they acted objectively reasonably. And I don't envy the court having to struggle with that, because it really is tricky. And you know, I was looking at the new pattern instructions for these cases. They differ quite a bit from the pattern instruction we modified for this case, and I think it reflects that struggle that the courts are going through right now, and maybe we'll get lucky at some point and the Supreme Court will give us a little better direction. But it's really tough, because in the pretrial detainee situation, we've been struggling with what the Fourth Amendment requires for a long, long time. And like you, I'm not satisfied with it either, because I try a lot of these cases, and when you have jury instructions that, you know, are still in the middle of this debate, it makes it tough. And so I appreciate the court's time. I appreciate the opportunity to present our argument. Thank you very much.
Thank you very much, Mr. Gilbert.
Your Honor, I ran way over.
Mr. Anderson.
I'd like a minute.
All right. Mr. Anderson?
Oh, thank you, Judge. I'm going to run to the podium. There are three things I want to respond to.
Can you wait?
You gotta
Yes,
get to the
I
podium, because she.
You have to wait. You have to wait.
I
Okay.
apologize, Judge.
You have to talk into the mic.
Yes, ma'am.
Okay.
The first thing is objective standards. They were trained not to do it. Everybody has said you cannot wait. You have to refer. If you promise, it's the worst thing you can do if you don't follow through. That meets an objective standard. The second is a point is the courts, and John just mentioned them, the court's 8th Amendment and 14th Amendment failure to provide medical care set out in paragraph 2 this exact issue and show what the court's proposed instructions mean. In paragraph 2 of the 8th Amendment, they say exactly what was said in this case. Defendant actually knew or was actually aware of facts from which it would be obvious that plaintiff had a serious medical need, and they failed to refer. The language in the 14th Amendment, 7.17b, is that the defendant knew or should have known that plaintiff had a serious medical need or strongly suspected facts. The first prong of that is clearly objective. The court has thought enough of it to include the difference between the 14th Amendment and the 8th Amendment in its new proposed failure to provide medical care elements, and I think it perfectly illustrates what we're talking about here. The objective need, of course, is knew or should have known, and then, of course, it goes on to say failed to take, in both cases, failed to take reasonable steps to alleviate the risk. That's all I wanted to say. Thank you.
All right. Well, thank you to both Mr. Anderson and Mr. Gilbert. And the case will be taken under advisement. And we will go on to the next case. Oh my, which is 23-1703, Abre Jackson versus Mark Anastasio. Ms. Van Fuck.
Good morning, Your Honors. May it please the court.
Good morning.
Abigail Van Hook appearing on behalf of Abre Jackson. Today, we ask this court to reverse the district court's grant of summary judgment and to allow Mr. Jackson's due process claim to go to trial. This case boils down to one issue, and that's whether under the Sandin hardship analysis, there's evidence of a particularly harsh condition in disciplinary segregation at Pontiac when combined with a 3-month duration was enough to establish a deprivation of a liberty interest. Under Sandin versus Connor from the Supreme Court in 1995, to prove a deprivation of liberty interest, an incarcerated person like Mr. Jackson must establish an atypical and significant hardship in relation to the ordinary incidents of prison life. This court...
Forgive me, did Mr. Jackson provide any further details as to the conditions that he experienced, such as whether he had made any request for cleaning supplies that were denied, or the extent of the mice and roach infestation, and the impact that that had on his daily life?
While Mr. Jackson did not provide details on requesting cleaning supplies, he was explicit in his declaration that what he experienced, which would be the inmates throwing feces, the no regular cleaning, the roaches, the mice, that these were atypical to the general population. And with that in mind, it establishes that regardless of his reaction to those conditions, that the conditions were atypical.
Ms. Van Hook, can I push you on one of those points?
Of course, Your Honor.
Okay. So when you look at exactly what Mr. Jackson said in his declaration, going to Judge Rovner's question, okay, when he talks about the West House and he talks about inmates throwing feces and urine, okay, the way he couches that is he says inmates threw feces and urine at other inmates while they passed the cells to go to hearings or whatever. Okay. Did he ever at any point come forward and say, and it happened to me too? In other words, do you see what I'm pointing at? Do you see what I'm observing? It looks like what he's doing is he's, in his declaration, reporting what he saw happen to others. Now, this is horrible. I'll grant you that. Okay, but did he ever say, and this happened to me when I was going to the medical unit or the library or the shower or anything like that?
Your Honor, in his declaration with regards to throwing feces and urine at other inmates, he does not explicitly state that it happened to him, but he is describing what he experienced in segregation. With respect to the feces and the urine on the walls, those factors do apply to the cell that he was in segregation. The roaches and the mice, those apply to the showers that he was using in segregation for 3 months, the contaminated water. This is the state of segregation that he experienced. However, with respect to the specific example of throwing feces and urine, he does not say explicitly that it was directed at him.
So what you're doing is you're essentially, don't let me put words in your mouth, you're essentially reading between the lines.
Yes.
To say, when he talks about urine and feces being thrown, when he talks about urine and feces on the walls, he implicitly is describing what he too experienced.
Yeah, yes, Your Honor, and I think it's a little more powerful than just reading in between the lines. This isn't a person that walked through segregation one day and wrote down what they think they saw. This is someone that was sent to segregation for 3 months and lived there for 3 months. So everything he's describing is a firsthand experience of what he saw daily and what he lived in daily.
Right, and what Judge Rovner's question is getting at is, why didn't he write that down in his declaration? What you just said.
Your Honor, I can't speak to specifically why he didn't write that down in his declaration, but in other cases, the emphasis of this court was on the fact that there wasn't a difference shown between general population and what the individual experienced. However, in Mr. Jackson's declaration, by him stating that unlike general population, that establishes that atypical hardship for everything that he described. And again, it's just the inmates throwing feces and urine at each other. That's the only statement that he wouldn't have clearly experienced since he was in segregation for 3 months.
Yes, and please, I know that you surely must understand, Ms. Van Hook, that we really understand that these conditions are deplorable. They're deplorable. On the other hand, they are the type of complaints that are not atypical of even the general population. What, if any, evidence did Mr. Jackson present to support the claim that the water was contaminated with bacteria that causes Legionnaire's disease? Because, I mean, is that the type of allegation that we can accept at the summary judgment stage without some evidence that would establish the factual basis?
Well, Your Honor, I think, or the case is established that even your self-serving testimony, if it's a declaration and if it's proper, it can be relied upon at summary judgment. He's providing his firsthand account of what he experienced in segregation. He didn't have a water tester with him, and we weren't able to test the water, but his firsthand experience and account should be enough to survive a summary judgment stage.
Oh, but that's the kind of allegation that we need some evidence, or else anyone could just say, yeah, well, there's bacteria in this water and it's causing Legionnaire's disease. I mean, we really need a little more than that.
Could I ask you about the issue of qualified immunity?
Absolutely, Your Honor.
I'll just, by way of background, we've been struggling with these solitary confinement cases for a long time, with kind of sliding scales about length and conditions and so on. And that makes the uncertainty in the standard for when due process requirements for solitary confinement assignments are appropriate gets very tough with a qualified immunity defense. I understand that you've argued that the defense here has shifted grounds entirely on qualified immunity. But if we were to send this back to the district court and the defendants then raise the right qualified immunity defense, in theory, what would plaintiff have to say in response?
Your Honor, can you clarify on what the right qualified immunity defense
The right qualified immunity question is, would it have been apparent to a reasonable prison official dealing with Mr. Jackson's disciplinary case that the combination of 3 months in solitary and the conditions that he describes would require the due process protections for a liberty interest?
First, Your Honor, we actually believe that the qualified immunity attaches to the due process violation itself, not necessarily the liberty interest analysis. Because an analysis where a situation where qualified immunity would cover you if this court hasn't ruled on the particular set of facts would just give people leeway to violate rights creatively.
Well, that's qualified immunity doctrine allows that. That doesn't defeat the defense.
In the Seventh Circuit, in the case Lyle versus Wellborn from 2019, this court said to proceed on a due process claim, you must demonstrate the deprivation of a liberty interest and a constitutionally deficient procedure. It is our understanding that qualified immunity applies to the constitutionally deficient procedure.
Well, but it also depends, it doesn't even, you don't even get to that if what's proposed is not a deprivation of liberty, right?
In theory, yes.
Suppose it's 1 week in solitary, okay? I don't think anybody thinks under current law that's enough to require due process procedures.
Actually, Your Honor, I think it is the other way around, because the reason why it is a deprivation of liberty isn't because it's solitary confinement or isn't because it's a punishment. It's because you only experience that punishment because of a violation in your due process hearing. Mr. Jackson's hearing was at fault. If he had had due process during that hearing, there's no way to say that he actually would have had the 3 months in segregation. So the liberty interest itself has to come after the due process analysis.
I'm not following.
Yeah.
Let me try it this way. I will want to ask the defense counsel about the reversal of the lost good time. But let's assume there's no loss of good time. There's simply a disciplinary hearing that imposes 1 week in solitary for whatever infraction occurred. If I'm a member of that committee trying to decide what the appropriate punishment is and therefore what procedures might be needed, how would I know whether the adversarial procedures of Wolf against McDonnell, or well, not the limited procedures of Wolf against McDonnell, are required?
Your Honor, what we're arguing here is that you don't have to think about how am I going to be covered if I violate this person's rights. If you sit and say, what are the rights that this person has, and let me have and conduct a hearing that maintains those rights. So
that would be an admirable way to think about this. But
thank you, Your Honor.
I'm thinking, look, I've got a prisoner in front of me who wants to bring in 10 witnesses and wants us to see all the video, and all we want to do is impose relatively modest sanction of a week in solitary. I don't need to give him any of those rights under Supreme Court, Seventh Circuit precedent, right?
Which goes to the qualified immunity standard. Qualified immunity attaches when there is qualified immunity will only become an issue if you violate a clearly established right. In your example, for the established Seventh Circuit procedure, you don't have to allow all of those. If, say, you didn't have to allow those witnesses, then you're fine. Qualified immunity attaches to you. However, in this situation, there was clearly established rights, as we saw in Ellison, that he should be allowed to present that video evidence, and he wasn't. So at the very first point of analysis is the due process violation. And once you have that violation, then qualified immunity does not attach. The liberty interest goes to whether or not our client has actually a valid claim for that due process violation. And I've gone well past my time, so hopefully I'll be able to still reserve some for rebuttal.
I will, of course, allow you to do that.
Thank you.
Thank you. Oh. All right. Mr. Rechtin? Hello.
Good morning, Your Honors, or maybe good afternoon now, Your Honors. May it please the Court. I am Assistant Attorney General Tim Rechtin, and I represent the defendants' appellees. This court should affirm the grant of summary judgment for defendants on Jackson's due process claim. Indeed, the court can do so based on several grounds. Specifically, Jackson failed to establish that he had a protected liberty interest, that the process he received was deficient, that the defendants were not entitled to qualified immunity, and that defendant Leonta Jackson was personally liable for any alleged deprivation of due process. Turning to the first issue and what the court was looking to at the start of the argument, Jackson has not provided any evidence to show that the conditions in his cell arose to exceptionally and unusually harsh conditions or deviated substantially from the ordinary incidents of prison life. No reasonable jury could find that. His conditions claim is the subtotal of it is all in a few short sentences that provide no description of his particular cell.
Could you compare his description of conditions in supervised or in solitary confinement to the Supreme Court's description in Taylor against Riojas, in which it summarily reversed a grant of qualified immunity?
I'm not familiar with that case, Your Honor. I'd be happy to provide supplemental briefing on it.
2020 decision, 592 U.S. 7, and it just took a couple of paragraphs. Shockingly unsanitary cells. The first cell covered nearly floor to ceiling in massive amounts of feces all over the floor, the ceiling, the windows, the walls, and even packed inside the water faucet. A clogged drain, no drainage, no heating. It wasn't very detailed, but it was sufficient for the Supreme Court to tell us that's enough to summarily reverse a grant of qualified immunity. Nothing to do with solitary confinement, just general conditions of confinement. I guess what I'm suggesting is I'm a little skeptical about your argument that Jackson wasn't specific enough here.
Okay, Your Honor, yes. So I don't know that particular case, if it was a due process claim for an atypical.
It was an Eighth Amendment.
It was Eighth Amendment. For this atypical and significant hardship, this court made clear in Lyle that just vague assertions about conditions aren't enough for a reasonable jury to determine that the inmate suffered from an atypical and significant hardship. Here, there are general statements about segregation generally, but nothing about his particular cell, and nothing about what happened to him.
Since it's summary judgment, why shouldn't we just assume that when he's talking about solitary confinement generally, he's talking about his own case? It's summary judgment.
He still had the opportunity to provide evidence to support his claim. He's got to come forward with more than just a conclusory allegation.
Could I ask you about the video here and the reversal on the taking away of good time credit?
Sure.
The petitioner or the plaintiff here tells us that the defendants denied the existence of the video in question until the day before the close of discovery, and did not make it available at the time of the hearing.
Yes, Your Honor.
Can you account for that?
I cannot account for that, Your Honor. I would say.
Does it help account for the reversal on the taking away of good time? Because that would be a pretty sure loser on habeas.
Your Honor, that issue is not here today. This is particularly the due process claim that doesn't have to do with the...
Well, it has to do... If you're going to take away the guy's good time credits, then Wolf against McDonnell applies, right?
Well, under this court's recent decision in Adams v. Regal, where the good time credits is restored, then the amount of due process...
That's my point. But you don't know that as you're going into the hearing.
Correct, Your Honor. You do. In this case, there's nothing in the record to suggest that was known going into the hearing.
May I ask? Oh, I'm sorry.
Well, go ahead.
Your Honor, to that point, in Adams v. Regal, it was restored, I believe, after the original hearing in which the video was, the inmate was denied access to the video.
I agree that's a remedy for a clear due process violation. to take away the loss of liberty that would have required due process. Could you help us deal with the apparent change of theories on qualified immunity? That was something raised in the reply brief. So.
Absolutely, Your Honor. This isn't a change of theory, so to speak. We've argued below in our opening brief at summary judgment stage that the defendants had not violated any clearly established rights of Jackson's. And that would include, and that the conduct at the hearing was not a violation of any rights. Under Jackson's theory, that conduct would include placing him in segregation for 3 months. So while we didn't specifically say placement in segregation in the qualified immunity argument, this is merely an amplification of that same argument that there is no clearly established right that has been violated by the defendants.
So, as I indicated to your colleague, we've been struggling with these issues for many years. And the standard, at least under Seventh Circuit case law, is uncertain enough that qualified immunity is usually going to be available. That at least when you're measuring in months, probably a solitary confinement assignment, that doesn't trigger due process rights under Wolf unless conditions are bad enough, and that's just hard to tell when they're bad enough, right? The question I'd like to hear your thoughts on is, should we try to adopt some brighter line standards for when solitary confinement assignments will trigger due process requirements under Wolf?
Your Honor, I would say, first of all, under Adams v. Regal, the recent Seventh Circuit case, the standard for deprivation of due process, or the amount of analyzing if there was due process below, is not Wolf. It's the informal, non-adversarial due process of Hewitt and that line of cases. I would also argue, Your Honor, that for qualified immunity, the Hardaway case, which we cite in our brief, specifically said that there isn't a clear line and acknowledged the very issue that you talked about, that simply this court has not announced, nor the Supreme Court announced a clear line. And there found, though, that there was qualified immunity and affirmed qualified immunity, a summary judgment of qualified immunity in that case. And that was with 6 months of segregation. So here the defendants are entitled to qualified immunity based on
the question, though,
case.
Should we articulate some brighter lines so that there's actually some room for accountability here?
I think the court can do that, and it would be welcomed to draw brighter lines. The Supreme Court has not chosen to do it, and specifically in the Wilkinson case mentioned that it wasn't going to draw a bright line. In that it even cited the Wagner case from this circuit that had asked the court to take that task on. But the court. So
should we try it ourselves?
The court should do what it thinks it needs to do to make to help the next case.
If I were on a prison disciplinary committee, I'd kind of like some guidance on this if I'm going to get sued as an individual defendant.
Sure, Your Honor, and understand that. This particular case, though, falls well within the case law that there is no due process issue here and no liberty interest that has been implicated. So I'm not sure.
Before you, go ahead. Finish your thought.
No, Your Honor, I was finished.
Just tell me this. Do you think that the conditions that were alleged by Mr. Jackson for the 3-month duration, would they be sufficient to trigger a liberty interest if, for example, he had alleged that the noise conditions were so onerous as to prevent nearly all sleep, or that the mice infestation was so significant as to cause injuries or otherwise threaten his health. Would we have had a different case here?
Your Honor, I see I'm out of time. May I answer the question?
You cannot escape the question.
Fair, Your Honor. So, couple thoughts on that. No, Your Honor, because first of all, those obviously are not the facts here. That the declaration here is bare bones and doesn't provide that kind of testimony. Second of all, these really are not the type of conditions, and I think the district court was getting to this in its opinion, but that these are not really the type of conditions that give rise typically to a due process claim, and that's because they are they're not inherent to the segregation. The sentence for 3 months of disciplinary segregation, it's not inherent to that sentence. It's not like the solitary confinement where there's no communication with humans that is typically an issue in these cases. So this would really have been better couched as perhaps an Eighth Amendment claim, if anything. But in terms of due process, I don't think it would make a difference because there's still no evidence that the officials here or the defendants here knew of these conditions when they sentenced Jackson to 3 months in segregation. And they certainly it's not clear that from anything in the record that was the case. So to answer your question, Your Honor, no, I don't think that set of facts would change things here.
All right. If anyone has anything else, no. Okay. Then.
Thank you, Your Honor. We would ask that the court affirm the grant of summary judgment. Thank you, Your Honor.
Thank you, Mr. Rechtin. And Ms. Van Hook, you asked for 2 minutes and you're going to get your 2 minutes.
Thank you, Your Honor. Starting off, I just want to address Judge Hamilton's question regarding the bright line. If this court should implement one, we say absolutely not. This is the type of situation that this court recognizes extremely dangerous in Curvin versus Barnes. It ignores the fact that these are people, the deep psychological effects that segregation has on a person. To say, oh, if you just do something under 2 months or under 3 months, ignores the fact that these are people whose due process rights have been violated, and that even just 3 days in conditions that are bad enough could just destroy a person mentally. So we absolutely oppose any bright line standard. We believe that is what the court in Sandin was referring to, is that this has to be a weighing of conditions paired with duration.
If that's so, plaintiffs in Mr. Jackson's situation will almost always lose on qualified immunity.
Can you explain, Your Honor?
Because a defendant prison official will be able to say, I don't know how this standard is going to be applied by the courts to this situation in front of me. Let's bad conditions for a week. You want that to be potentially actionable.
Yes.
It might amount to a constitutional violation, but it's hard for me to see how we clearly establish that a prison official should know that going in without drawing a bright line.
Again, the prison official can claim qualified immunity if they are conducting themselves in a way of a clearly established right. We're not saying that you have a clearly established right to stay out of segregation, it's just that once there's been a due process violation, if you're placed into segregation that is deplorable enough conditions or long enough, it could give you an actionable right because it's a deprivation of liberty interest. Again, I would like to really separate the qualified immunity attaching to the due process and whether or not that's actionable because of the liberty interest that you lost. And finally, I would just like to ask this court to reverse the district court's grant of summary judgment and to conclude that the deplorable conditions of the disciplinary segregation at Pontiac, combined with Mr. Jackson's 3-month segregation, were a deprivation of a liberty interest, and to remand his due process claim for further proceedings. Thank you so much.
Well, thank you so much, and thanks to both Ms. Van Hook and Mr. Rechtin. and the case will be taken under advisement. We're going to go on to case number 5, which is 23-1948, Malcolm Sanders versus Michael Meisner.
Good afternoon, Your Honors. I am Tim Pravis with a short O, and I represent Mr. Sanders, and via the rules of standing, also the interests of the two black potential jurors who were kicked off the jury. Perhaps all of you know that the late Chief Justice Rehnquist was a big advocate of oral argument, and he wrote law review articles about it, saying it should be emphasized and there shouldn't be so many limits on time. I regret to say that the press of your business, the volume of your cases, makes things like that impossible, so that the only real purpose of this argument is for me to answer your questions. So I will just make 2 short points, hopefully no more than a minute or 2, and then take all of your questions, answer them as best as I can. The most difficult thing for appellate counsel in a case like this is to convince a court, any court, of facts which the general public is already well aware. And so we all give...
all of us are familiar with the possibility of police actions that are inconsistent and based on race, okay? Could you address our opinion in United States against Carter, which was not a habeas case, but a direct appeal in which we rejected a pretty similar Batson claim?
I can't, Your Honor. I regret to say I've not read that case.
Let me ask you, can I ask you?
Yes, Your Honor.
Here, one of the things that makes the argument you're making anchored in Strouder difficult to follow is that the U.S. Supreme Court today applies its Batson framework to allege race discrimination. I mean, I think the U.S. Supreme Court thinks of Batson versus Kentucky as the primary case. Hernandez versus New York is in the same line, and your brief doesn't present an argument within the framing of Batson and Hernandez.
Yes, Your Honor. And that is the reason that in my reply brief, I emphasized my citations to Flowers versus Mississippi. The majority opinion written by, let's see, who wrote that? Justice Kavanaugh, goes into a great deal of history about the whole concept of discrimination against minorities in juries. And
Did Flowers displace Batson and Hernandez
no,
as far as the
I'm
governing
not saying
framework?
that. No, what I'm saying is that there's a reason why Justice Kavanaugh went into such detail about the history of Strouder and the subsequent events, and I believe that reason is giving us a hint. You're all, I'm sure, familiar with the opinion of, well, nearly all academics. I cited a seminar about that in one of my briefs, the reply brief, and some judges that Batson is a complete failure.
Mr. Provost, I think I'm sorry, Judge Rubner, go ahead.
No. Mr. Provost.
Excuse me, Your Honor, it's Pravis with a short O.
What?
My name is Pravis with a short O.
Oh, I'm so sorry.
It's all right.
Mr. Pravis, What case clearly establishes that it is unconstitutional to base preemptory strikes on a prospective juror's report of a negative interaction with the police? Because I fear that that's what you're asking us to do. What case?
Well, there is no U.S. Supreme Court case. I cited in my reply brief cases from state courts, and I want to apologize to the court about this. There's a concept now floating around called the dual motivation doctrine. And I did not know when I first, in state court, I didn't know that this concept has been rejected by the Wisconsin Courts of Appeals. I also, let me take my brief time here to...
Mr. Provost, let me, with the time running short, look, maybe I'm thinking about this wrong. The only way that Mr. Sanders can prevail on appeal is if he persuades us that the Wisconsin Court of Appeals, the last court to have considered his Batson challenge on the merits, committed legal error. And that legal error is measured by the standards that Congress applied in 2254D. It's a federal habeas case. That's the only way. He's got to convince us that there was legal error.
Well,
so
I have to convince you. Sorry to interrupt you, Your Honor, but the further on, what I believe is the implication of Flowers is that if you read Batson carefully, there are at least 3 places where it says that Strouder is the established law of the U.S. Supreme Court.
Okay, unless and until the U.S. Supreme Court overrules Batson, because we're not in a position to do that.
Well, no, I don't. Well, Your Honor, I believe that there is... I am trying to establish, yes, there's no question about it. My brief with respect to driving while black is basically it's a Brandeis brief. So you have to buy that. It's facts which not enough courts have taken for granted. But
Mr.
yes, I beyond sorry.
Here's our case. The preemptory challenges were issued based on responses to questions by 4 prospective jurors as to their negative experiences with the police. Now, 2 of them were black, 2 of them were not black. And federal rule indisputably allows preemptory strikes based on prospective jurors' reports of negative interactions with police.
I understand that, Your Honor.
Even though, you think that we should reconsider those holdings in light of evidence that police interactions are, and they are, often based on racism, that argument cannot succeed in the context of a habeas action because it requires a change in the law that we cannot make. Only the Supreme Court can do.
Your Honor, if you all feel that way, I can't. I have real no dispute about that, and I will have to go higher with my argument. I would, before closing, I would like to mention that this dual motivation doctrine, which could save discrimination based on driving while black as a reason for kicking a juror off, was kicked in the pants by the South Carolina Supreme Court. Page 14 of my brief. Also, I do have a Supreme Court hint in where's this? Perquette versus LM was talked about a situation where, well, let me quote from what I wrote here. If I may go briefly beyond my time here.
Sure.
Yeah, here it is. I'm sorry that it took so long. At 514 U.S. 769, the Perquette case said that they weren't striking. They were affirming the strike because what was pointed to was not a characteristic that is peculiar to any race. And the other cases I cite on the following pages are state cases where they picked up on that, and where there were cases where the characteristic that was used by the state was a peculiar one to the particular race. One of those cases was where there was a white juror who was called a redneck by the state DA, and the reviewing court in that case found that couldn't be used despite any other fact. I apologize if I've wasted your time, and I guess if you have no more questions, I'm done.
Our time is never wasted by our lawyers, and I thank you. Thank you.
Thank you. Oh, by the way, I would like to say that I have been at this business for 40 plus years.
Do you want to go before the mic so you can be
Oh, I'm sorry.
heard?
I would like to say that I have been at this business for 40 plus years, and I have never seen a bar of judges that were as careful and as well prepared and asked the incisive questions, and it was a pleasure to appear before you all.
Well, we thank you very much for that kindness, and we really appreciate that. Thank you. Miss, is it Baichi or Bice?
Bice, Your Honor.
Bye.
May it please the court, I'm Sonia Bice. I am an Assistant Attorney General for the Wisconsin Department of Justice, and I represent the respondent in this matter. As this court's questions to Attorney Provis indicates, my point is this is a habeas case. It's in a habeas context, and the question on appeal is whether the district court was wrong to deny Mr. Sanders' petitioner's petition for habeas relief, because, as Judge Scudder said, it was the state court's decision denying him relief was contrary to or an unreasonable application of Supreme Court case law. As counsel conceded, there is not Supreme Court case law that holds that negative experiences by a juror are not race-neutral reasons. And I believe that that's dispositive of the question. I'm happy to take your questions. I don't want to take more of your time than is necessary.
Well, all right, I'll ask you something that although a habeas action with its focus on clearly established law, it is not the proper place to raise this argument. Is it inconsistent with the underlying purpose of the Batson rule to allow peremptory challenges that are based on negative interactions with the police when those very interactions were themselves based on race?
Your Honor, I think that's a fair question. I was lucky in this case to be in a habeas context and facing only clearly established federal law as determined by the Supreme Court, and so my focus is very narrow. I think that courts will struggle with this in direct appeals. However, and times have changed. The cases that this court addressed in Carter and I think Hinton, Stafford, those are all cases from the 90s. And in those cases on direct appeal, even without the onerous restrictions of habeas, this court held that those kinds of negative interactions with police did constitute race-neutral reasons. However, to your point, I do not believe that in any of those cases was racially motivated or allegedly racially motivated negative experiences at issue. So I believe, I think it's a troubling question, as was reflected by the state court dissenting judge in this matter. Even he was unable to say that it was contrary to any established law at that point.
Wow. Okay. We thank you very much, Ms. Bice.
Thank you, Your Honors.
Thank you, and thank you to both of you, and I hope you have a good trip back. Thank you. All right. We're going to go on to the last case of the day, and that is 23-2844, United States versus Gerald Sewell. Hello, Mr. Newton.
Yes, Your Honor. Talmadge Newton on behalf of the appellant Gerald Sewell. May it please the court, opposing counsel. The facts of this case are unsettling, but the appellant is not asking this panel to acquit him or even to find that he was entrapped. The appellant is simply asking that his defense of entrapment be submitted to a jury for consideration. A jury, and not a judge, should weigh the facts and the evidence as presented at trial and make the ultimate determination in this matter. The district court...
I have a question. You have so little time. Did Mr. Sewell at any time stop responding to the posts by Brionica and then and was then urged by her to re-engage?
No,
or did he stay in the conversation without any gaps in time?
Your Honor, I understand the court's question. This is not a case such as Mercado that lasted days and days, or Anderson even, where people drifted in, went silent, and were brought back in by the federal agent. This was a conversation that was relatively short in duration. Like many modern electronic conversations, it starts and stops and stutters, and presumably people are doing other things, so it is not a necessarily continuous flow, but I don't think anybody could say that the conversation was paused or that Mr. Sewell was brought back into it after a lengthy pause.
Now, although Mr. Sewell expressed reluctance based on Brionica's purported age on a couple of occasions, how would we say that the one line, as you just noted, the one line responses by the agent went beyond merely ordinary presentation of the opportunity for the offense and instead constituted repeated attempts?
I really do believe, Your Honor, that... Oh, I'm sorry.
I'm not done. I'm sorry.
No, I'm sorry.
Sorry, I'm so long-winded. But at persuasion that would be sufficient to cause a person who would not otherwise commit the crime to do so.
And I think, Your Honor, that when weighing the submissibility of an entrapment instruction such as this, it is not any one thing. And I think that any one aspect of this can be overcome by the government's position. But I think with the totality that it is the government's post that's out there, there is an age-altered photograph, that the initial conversation, the court will recall, as it starts somewhat benign, what are you looking for? I'm looking for a ride, ... and maybe something else. And you? I'm looking for that from a woman. This starts off rather neutrally. And I think when you combine that the government, such as in Anderson, is the first to become explicit and take it sexual, when you combine that there are two arguable attempts by the appellant to withdraw, that he is encouraged back in, this is the totality, I think, that supports the issuance of the instruction by the district court. And Mayfield cautioned that assessing the sufficiency does not mean that the judge weighs the evidence and decides whether the defendant is believable. And certainly an attack on the sufficiency will be leveled by the government in their closing argument. And ultimately, I believe, though, the point is that the jury should decide this defense. It is not appropriate for the defendant with this matrix of facts to have the submissibility of the defense denied to him at the outset. I think there is sufficient evidence that existed before the district court to allow him to present this and to have it argued both by the parties.
Mr. Newton, can I ask you to comment on one aspect of this stands out to me in the transcript here?
Yes, Your Honor.
After Mr. Sewell recognizes the age and expresses concern about the age, that's what you were referring to a second ago.
Yes, Judge.
You are jailbait was his comment, etc. Okay. We come to a portion of the exchange where there's absolutely no doubt it's sexual in its discussion, and then at 1:30 and 1:32 in particular, there's a pause in the colloquy. I'll let you look at it there.
I'm caught up, Judge.
You got me? Okay. There's a pause then, okay? And at that point, the pause runs for about 40 minutes, okay? And then Mr. Sewell re-engages by asking a quite particular question. What's the address? Meaning, where can we meet? And it goes on from there, right? So he had an opportunity to be concerned enough about the age to just say, look, I'm done. 1:32, I'm done. I'm clearly, this is, territory with a minor that way. But then he picks it back up, and he's quite persistent with it. I wish you were 18, but I mean, he keeps on going. I'm on my way. I'm on my way, etc. So that's what gives me pause on the, focus on whether there's, undue inducement here.
And I think pause is appropriate, and I think that the exchange is certainly unfortunate, especially for defense counsel. But I think there are other aspects as well. There's a 2-hour period at the beginning before age really even comes into this as you look at the time frame, where the initial text begins at, Your Honor, I'm in the appendix on Government Exhibit 17.
Yep.
Starts at 10:13, and her age doesn't come in for 2 hours until nearly 12:22. And then after the reignition that you just referenced, Your Honor, he does bring up age again, where at 2:40 he says, I wish you were 18. 4 minutes later, Brionica, who's in fact, of course, an FBI agent, a male of age, says, so I don't get a choice. I don't need to know your real name. So there's another hook back in, even there. And I think it's appropriate for a jury to consider this, that a jury could consider the nuances of conversation. I watch my teenage daughter having conversations on text, Snapchat, and Instagram at the same time. And those are staggered in the way they come out. And I think that though your concerns would be the government's position in closing argument on why the defense of entrapment is not available to Mr. Sewell. But I think that should be a question for the jury. And I will, if there are no pressing questions, I'll reserve my remaining time. Although, any questions? Okay,
Yeah.
I will sit down and reserve my remaining time. Thank you.
You're going to get the full 3 minutes. And hello, Ms. Reppert.
Good afternoon, Your Honors. May it please the court. The appellant offered insufficient evidence of government inducement to commit attempted enticement of a minor, and so the district court properly refused a jury instruction on entrapment. Of course,
May I stop you for a second? The initial comment, I don't know anything about social media because none of us are on it. The initial contact here was on this Craigslist. Is the age requirement for posting on that site 18 years of age? You have to be 18.
Judge, honestly, in terms of the evidence in the record at trial, I don't believe there was any evidence to say or not say that you had to be a specific age to post on Craigslist. Craigslist is a site that is commonly used for a number of things to buy and sell items. But in this particular case, there's something called the missed connections section, and that is commonly used for finding sexual liaisons. But there was no evidence at trial whether you had to be 18 or not 18, so I can't speak to what Craigslist requirements are, other than to say that I don't believe there's a certification process to be able to post an ad where you have to verify you're 18 or not. Unlike some of the other cases this court has heard in attempted enticement of minor cases where it's a dating site where you have to make some sort of verification that you are 18 years old.
Now, in his initial response to the post, he stated that he was a man seeking a woman. And the agent responded that, quote, he might have found that. Wouldn't that be interpreted as a statement that she was a woman and therefore indicate that he was engaging with an adult at the outset?
Yeah, potentially, Your Honor, that from the outset where it was the only thing that the advertisement said was looking for a ride. And so where appellant then messages that, saying, where are you looking to go? And he talks about he's a man seeking a sexual liaison with a woman. You might have found her could be interpreted as potentially being an adult. However, within a couple of messages, within 2 hours, Brionica then drops down saying, I'm 15, how old are you? And this was after an age regress photo was provided to Mr. Sewell as part of this communication. And then after this exchange of the photograph and the age reveal, I'm 15, we're essentially off to the races. There was multiple times that Mr. Sewell said, What do you want to do for a good time? Where can we play at? Where can we meet at? What's your address? What's your phone number? He explicitly discussed sexual acts that he wanted to commit with Brionica after this age reveal, saying, I'm 15 years old. And so this entirety of the conversation, which spans approximately 9 pages in Government's Exhibit number 17, it's approximately 89 messages going back and forth. The totality of that demonstrates that there was no government inducement. Government inducement, it means more than mere government solicitation of a crime. And the breadth of these messages going back and forth is solicitation of the crime and nothing more. And so a defendant, to be able to get an entrapment instruction, must proffer evidence on both elements of the defense, that being predisposition and inducement, and that is to say that the defendant must point to evidence in the record that would allow a rational jury to conclude that he was entrapped. And that,
here's the thing. When he learned of her age, of course, he expressed this reluctance, both initially and again, subsequently. And after each of those expressions of reluctance that were based on her age, the agent responded by portraying Sewell's reluctance as a sort of, not a sort of, but as a repudiation of her right to autonomy over her own sexuality. Do you think that in any way calls into question the factor of inducement?
I don't, Judge. Respectfully, I think that this falls more in the bucket of solicitation versus the plus factors that Mayfield discusses, which is to say that inducement means more than mere government solicitation of a crime, that there has to be a plus factor. Mayfield gives a non-exhaustive list of other conduct to include repeated attempts at persuasion, fraudulent representations, threats, coercive tactics, harassment, promises of reward beyond that inherent in the customary execution of the crime, pleas based on need, sympathy, or friendship. And so in examining what the agent's responses were to some of the statements by appellant, we would put that more in the solicitation of the crime bucket versus the plus factors that this court articulated in Mayfield. That does not.
Would you be kind enough to distinguish, if you can, Leal?
I'm sorry, distinguish what?
United States versus Leal.
Oh, Your Honor, the cases I have before me, I could talk about Mercado, I could talk about Anderson. Unfortunately, I don't have that case readily available at my fingertips, so I would be unable to do that. But of the 2 cases that I believe both myself and appellant have cited to in our briefs, there have been 2 cases post-Mayfield that this court has considered in terms of attempted enticement of minor cases and the denial of an entrapment instruction. I do think those 2 cases are instructive in terms of the contrast between those 2. Mercado, where this court said that the denial of the entrapment instruction was proper, which I think those facts are very much in line with the facts of this case, versus the facts in Anderson, where this court, actually Judge Hamilton, you wrote the opinion in Anderson, talked about the 11 direct attempts by the purported minor to have the individual come meet for sex, that there was use of you wasted my time. There were a number of things that were present in Anderson that are simply not present here, and that these facts are more in line with Mercado, where this was just the solicitation of the crime versus any of the plus factors contemplated by Mayfield. I hope that answered your question, Judge Rovner.
Thank you.
Thank you. So to summarize the facts in this case, the evidence that appellant points to, the only evidence were the chats in this case. They're summarized in the government's appendix in Government's Exhibit 17, and That 6-hour conversation from beginning to end demonstrates that what happened in this case was mere government solicitation of the crime, and that the plus factors contemplated in Mayfield did not exist. There would be no rational jury that could find entrapment in this case, and because of that, the district court properly refused the entrapment instruction. We would ask that this court affirm the judgment of the district court. If there are no other questions, I would thank the court.
And we thank you. Thank you very much.
Thank you. Your Honors, the truth is this case is neither Mercado nor Anderson. It's somewhere in between. I think that Mercado and Anderson, as post-Mayfield examples, are very different cases, and this doesn't match the facts of either. I think this is going to be a pattern before this court of continuing to zero in on exactly what the explicit standard is. But as Anderson said, the accused is entitled to present the defense at trial if he shows some evidence that supports it. And the court highlighted that the initial burden is not great. The defendant must produce some evidence from which a reasonable jury could find the government inducement and a lack of predisposition. And I think that Mr. Sewell met that burden at trial. For these reasons, and those set forth in the briefs, the appellant is requesting that the judgment and conviction be set aside and this matter be remanded to the district court for a new trial consistent with the instructions of this court. If there are no further questions, I'll end my time.
And I would like you to just stay there for a moment so that we can thank you properly for taking on this case and for doing such a fine job for your client. We are so grateful. And we are as well very grateful to Ms. Reppert. I'm sorry that the courtroom wasn't more crowded, so that, particularly with young lawyers, so that they could have heard that truly, just you both just did such a good job. We really are thankful. And we'll take the case under advisement, of course, and we will adjourn until tomorrow morning at 9:30 with our sincere thanks to everyone. Be well. Thank you.
Thank you, Your Honors.